Boom. How is everyone doing? It is a lovely Monday. Um, as lovely as Mondays can be. I mean, Mondays Mondays are not anyone's favorite day of the week. Um, but and I mean, Alberta's got an election going on, so um, if you're in Alberta, vote for one of the awful candidates. That's the usual election message. Um, if you didn't vote, you don't get to complain. Although I think everyone's got a right to complain. So, how is, hopefully everyone's got something sort of pleasant to drink here. I've just got Coke because I am really tired. And I think if I started out with something at all, um, anything more alcoholic, I would probably fall into nap mode, which is not where I want to be right at the outset. So, how's everyone doing this morning? Let me know. Let me know what you've got sort of in your cups today. Whether that's something fun, something, or water, which means you make good life choices. We don't all make good life choices, but water is an excellent life choice if that's where you're feeling. Um, yeah, it's we got a lot on the docket today, and I'm feeling like there's some fun things on the go. So I see Nurse M is saying, "I'm so tired." I feel you. I feel you 100% on that one. We've got Diet Coke. That's a great option. Uh, Rosé with pasta. Nice. Uh, Lindsay's got a bank holiday, but woke up with the whole back fully seized up and unable to move. I've been there, and it always seems to come on days when when you would have had the day off, doesn't it? Green Lady, gin, chartreuse, and a dash of lime. I've never had it, but it sounds good. Um, I like gin. I like a dash of lime. I don't know. I don't know what the chartreuse does to it, but I'm betting it's probably tasty. Sweet tea in Texas. So, um, I didn't realize what sweet tea was for a long time because I thought it was just kind of tea with sugar. And sweet tea is tea with sugar, but it's tea with sugar on epic levels of steroids because um, I didn't realize just how much sugar goes into sweet tea. Like it has to be mixed well hot levels of sugar because you're super saturating it. Um, I like sweet tea, but I always feel like I'm going to die drinking it. But that might not be a bad way to go. Amaretto sour, I make fun life choices. Nice. Give me 5 minutes and it'll be a ginger beer. I love ginger beer. That's wonderful. OJ and pineapple fried rice for dinner in Ohio. Nice. Guinness draft from North Carolina. Good stuff. English breakfast tea with milk and sugar. Good place to be. Generic Dr. Pepper in Southern Arizona. Um, is it like, they often call those things funny names, so I'm curious. Ginger beer and a water chaser. Nice. Um, Shiner Bock beer and water. Nice. Lara M is asking, how was date night? My wife and I did some gardening, and it was quite pleasant. We're both out there digging around in the dirt, getting some plants planted. Hopefully, our garden turns into vegetables and not dirt and weeds. But we will see. We're really good at dirt and weeds. That's really our skill set. So we're trying for vegetables. Uh, I don't know how to pronounce the name, but greetings from Haarlem, the Netherlands, drinking energy drink and smoking weed. Hey, smoke them if you got them, and it's legal. Pink Lady Gin and Tonic, nice. Prototopics, Blood of My Enemies, awesome. Prototopics, let me know if you want an invite. I can toss you one. Just shoot me a message on Twitter there. Crazy Cat Queen, I can't believe I'm actually drinking water. What the heck is wrong with me? I don't make good life choices. I mean, other than on YouTube followings. Well, thank you very much. Hydrating properly after working too hard and too long in the sun. Good place to be. An obscene amount of sugar. Yeah, it's ridiculous. So for the people who aren't sort of familiar with sweet tea, it's so I tried making it, and I was like, whatever, this isn't much. And somebody who was familiar with sweet tea is like, this is not how you make it. Go online, look it up. So I looked it up, and you basically, because you heat up the water, you are super saturating it. So it's more sugar than would normally go in that much water. It's basically tea made with simple syrup, which is impressive as a beverage. Rosalind is asking, did I win the election? I always lose elections. Whatever is going on, I always lose. I guess I can pull up the Alberta election. There's probably live results here so I can see what's going on there. It wants me to do a CAPTCHA with tractors. There we go. Follow election results live. We'll see what we've got here. Although they don't close until 8 p.m. So we're not going to see anything for now. But it looks like I've got a live results map going. So that's fun. And as per usual, this is mostly going to get decided by Calgary, which, polls close at 8, so there's nothing yet. We'll see what we can see, but it's going to be late before we get answers. I've heard of Canadians drinking hot maple syrup. Is that a thing? I've never heard of that. But what you do get in Quebec, which is actually quite neat, is if you go to the places where they produce the syrup, and it's winter, sort of the syruping time, what they will do is pull out syrup, and it's hot, and it's then they'll pour that on like packed in snow, and so as it hits, it sort of hardens and becomes kind of taffy like, and then you can pull that off, and it's basically candy. So that's the thing that happens. But White Buffalo's asking, what are you running for? I'm not actually running in this election. I am just a voter in this election. But all of the results have me losing. So, Cabane à Sucre is the name for it. Yeah. I think in English, sometimes they're called sugar shacks, but that also could mean something else. Is it true that there's a national supply of maple syrup that is only to be broken out in an emergency? Yes, Canada does have a strategic maple syrup reserve, which we can tap into in an emergency, or just to, it's partially also price management. Somebody once robbed the maple syrup reserve, so that was interesting. They stole millions of dollars worth of syrup. And they got caught. So I'm just looking here. Runkle, do you have the same type of election system like an electoral college as we do in the USA? Or do you say it would be basically decided by Calgary? No, I mean, there's ridings and so forth, and whoever gets the most MLAs gets the seat. That's kind of how that goes. It's complicated, but Vez from Quebec, we drink a half-made syrup called Petit Réduit. It's a bit more concentrated than maple water. So fair enough. So that'd mean that basically they've partially reduced it towards syrup, but not all the way. Amy Evans is saying, sugar, is that why emergency energy? I think it's just that governments stockpile all sorts of weird things. So you get places that have like cheese reserves and so forth. So it's all sorts of things. So how do we start this off? Well, let's start this off by, I guess, tales from legal advice, because Reddit is a place. Now I'm going to slightly dox myself, but I've already kind of, done that. Oops. Runkle, how was the escape room? So maybe I'll just hit log out before I do that, just to. All right. But then we get ugly Reddit. All right. So how was the escape room? I didn't do the escape room. That's a reference to a tweet about something that looked like a very scary escape room because it was posted on an abandoned building. All right. So let us do tales from legal advice, because I kind of want to make a bot that just is like goes into the legal advice subreddits and just posts lol to everything. I feel like in most cases it would be appropriate, but not all of them. But let's bring this one up. All right. So, fake marriage partner is asking for alimony. This is the kind of post that makes lawyers go, "What the heck?" All right. So, I come from a very poor background. And in university, a classmate approached me with an offer of $25,000 to fake marry a 40-year-old foreign woman and help her and her kid get their citizenship. If you're wondering, this is fraud. This is a bad idea. And the government tries to track this stuff down, but they're not always successful. The offer was quite generous at the time and could cover multiple years of my tuition, so I accepted, which is bad. This is a really bad thing. So you might be wondering, what could go wrong? Well, let's talk about what could go wrong, because it's going wrong in this one. So it says, fast forward about 6 years, the woman and her child are now both Canadian citizens. Now that she's a citizen, as part of our agreement, we divorce and finish the business deal. However, I'm now a software engineer making about $250,000 before tax at a big tech company. She's asking for a substantial amount of alimony and child support, about half my income, so about $120,000 a year. I'm stuck in a rock and a hard place now. I know I made a dumb decision to assist in citizenship fraud university, but I was a broke kid who could barely afford his tuition. What can I do now? Well, this is a real fun one because there's all sorts of elements to this one, like lots of different elements to it. So let's talk about the starting point. Starting point begins with citizenship fraud, to the tune of $25,000, which is the kind of thing they will send you to jail for. And that's a big deal. So then it turns around and now he's doing, there's a divorce. And basically she's engaging in some fraud too, because now she wants the child support and alimony, knowing that this was never a real marriage. Now, whether or not she can get child support, we'll have some questions as to whether or not he's had anything to do with her kid. But that's a matter for a family lawyer. The problem is that if they're actually litigating all of this, well, then guess what's going to get dragged out into the open air is that fraud aspect. So he's stuck between paying $120,000 a year for the rest of that kid, like the rest of that kid's probably 20-year span, which is a lot more than the $25,000, right? And yep. So he's got that choice or jail. Legally speaking, he's in some real soup. I'm not going to give this guy any advice because, of course, he's not my client. I don't know what the deal is and whatever else, other than just to say, holy crap, dude. So this is a great lesson as to why not to engage in citizenship fraud. And people are saying, is that his kid? Well, what the law sees, hey, you've been married to this woman for 6 years and taking care of her kid. I mean, I'm just thinking what I would probably do at this point is probably turn myself in on the fraud, or contest it, and testify to the fraud in court. Get an annulment. But really, this guy needs a young lawyer and an old lawyer, to steal the old line about a young priest and an old priest, because he needs a criminal defense lawyer, and he needs a family lawyer. And yeah, it's nuts. So he's got some problems there. This is why it's a real bad idea to play these kinds of games, but people do all the time. And the government will actually try to track these down. This is a really good question. Would the immigration fraud negate her citizenship? Potentially, yes. There are very few things that can revoke your citizenship once you get it, but one of those things is pursuing that on the basis of, of fraud, of lies. Now, the other thing is that she may not actually have much choice. I don't know what her income situation is, but if she's applying for support, they'll probably be like, well, where's dude in this picture? So yeah, it's tough. So legal advice is, by the way, the legal advice forums are pretty bad places to actually go to get legal advice. I read them sometimes for entertainment, but a lot of the advice given there is terrible. Legal Advice Canada is, believe it or not, better than legal advice with nothing after it, but it's still not a good idea. So yeah, how's everyone feeling about that particular gong show? Because I feel like that is all sorts of bad life choices, to be had right there. All right, let's talk about some other fun stuff here, because there is a bunch of things to discuss, and I realized that I forgot to grab one of them off of Pacer. I still don't have the Afroman update, so that I should probably try to get, or if somebody's got it handy, shoot me a message with it. I'll probably have to grab that a little later. All right. I see. Yeah, if that's me, I'm telling her I know I'll turn myself in and she'll get deported, or she can withdraw the alimony demand and go on her way, which is actually a crime to tell her this, believe it or not. Because if you tell her this, now you're committing extortion. And now you're in, now you've got a new problem, because the threat to reveal information like that, even though revealing the information is legal, the threat of do something or else I will reveal it is itself a crime. So, you can't go and send her that, like, do this or else, but you could potentially just be like, hey, I've turned myself in, and you're not getting anything. So, yeah, there's some not great options on all of this. All right. Yeah. What is it? Runkle is not giving any official legal advice. If you need any assistance, please contact a local attorney's office. Yep. Jane Babe. Yes. The difficulty on all of this is different places. So let me see. I'm going to see if I can figure out a way to get you a membership for that. So I'm just trying to see if there's a way for me to do a specific sort of provision to you. So that I feel like I should do if I can, because you've been a long-term supporter there, and I don't know. So I will try to figure that out and try to get you in on the member chat, Jane Babe and Luxor, because yes. All right. Let me just see here. I see. It would be a shame if you caused any attention that ended up getting you deported. You got to be real careful on that. But this is the good point. He's got the income to hire a fantastic attorney. Yeah, if you're earning $250,000 a year, I can tell you that a lawyer will be quite happy to see you walk through their door. Rob said he can't even get memberships for his mods. I will. Okay, that, yeah. Isn't there awful integration between YouTube and Patreon? There is. Patreon is awful, and there's a setting to allow just members and Patreon. Ask EDB. Okay, I'll have to talk to EDB about that. But Jane, Babe, and Luxor, I'll figure out something here, so we'll get you set up if we can. So, all right. Now, just you can't extort the extortionist. No, you can't. Unfortunately, there's all sorts of things you just can't do, and that is one of them. Let me just see. I'm trying to find. There's a wonderful set of filings that I want to look at here, and I'm just trying to pull it up on on all of this, but I'm having some trouble. Give me a second here. I'm getting frustrated with myself because I should have had this ready to go, and I had it somewhere else, and it is frustrating. So let me just try to find this here while I'm while I've got you on the line. There we go. I think I've got the document. Where's the full thing? Come on. Where'd it get uploaded? All right, here we go. I think I've got the full thing here. We're just going to download it. And now we're going to open it. Because, yeah, something unusual happened. And there is this thing that you don't really do as a lawyer. So let's talk about LSAT scores, because LSAT scores are a thing. The LSAT, if you're not sure what the LSAT is about, is it's a really difficult test. It's a the LSAT is a test where you basically just you have to do some reading comprehension. So it'll give you like a block of text, and you've got to figure out certain language from it. You've got sections that are what they call logical reasoning. And so logical reasoning is stuff where it's you read through these little tiny passages that might have they might have some sort of like a little logical structure to them, a little mini argument. And so the mini argument there is its own weird little thing, and then it'll ask you questions about it. And they also have these things that are logic games, and logic games are they're like a puzzle. It's like, if you have two canoes and Joe won't sit with Bob and Mary has to sit in front of in front of Sam, but not necessarily in the same canoe. And so you get all these rules, and then you have to figure this out. I actually thought the LSAT was a lot of fun, but I'm a weirdo who loves puzzles. So I thought the LSAT was a lot of fun. Most people hate the LSAT because it is difficult. So you take that LSAT score, you take the LSAT, you get a score that is a percentile score, or it's actually a score from 120 to 180, but then you can convert that into a percentile. So 120 is the worst score you can get. 180 is a perfect score. And then once you use that to get into law school, you basically never talk about it again, because it's kind of gauche. So And Pants is asking, Ian, did you get time added on for the LSAT for ADHD? No. There is a process to do that. And I will tell you that I looked at the process and it was complicated and long. And it's got a bunch of deadlines. And I ADHD'd my way past the deadlines to apply for any sort of accommodation on the LSAT. So I didn't get any extra accommodation. I just did it the same way everyone else does. So, yeah, no extra accommodation because I was too attention deficit to apply for accommodation for attention deficit. So I should have done a swoop, but it's too late now. All right, so let's look. Now, this is what caught the attention of the world because lots of people saw this and went, what the actual heck? So let's pull this up. Share screen. All right. Whoops. Let's try to embiggen that. I think that's as embiggened as I can make it here. No, wait, we can get it bigger. Except that as I try to make it bigger, it just gets smaller. Great. So I'll read this to you guys because it is, it's really exceptional. So coming soon, the Blount Law Firm. I don't know if that's the right way to put it. Blount. Coming soon to the Dublin, Georgia area, the Blount Law Firm, or Dublin, I guess, I don't know, will be opening in Sandersville, Georgia on May 15th, 2023. I don't know if it's actually in, so I see people saying this is how I can embiggen it. So there we go. We'll try for maximum embiggening. Founded by Mark J. Blount, Esquire, a 10th generation Georgian. Now, in Canada, you don't use the Esquire. We just don't. With the exception of like some people who are way too far up their own butts. So in Canada, if you see Esquire after somebody's name, it just kind of marks them as a jerk. I don't know if that's the case in the US, but I've heard that the rule is basically that you don't put Esquire after your own name and you put it after other people's names. I don't know. So, yeah. All right. I see people having different theories on pronunciation. A 10th generation Georgian. Who gives a how many generations of Georgian you are? The scorer of a 173, the 99.7th percentile on the LSAT, a 169, roughly the 95th percentile on the multi-state bar exam, portion of the Georgia bar exam, and a total of a 331 on the Georgia bar exam overall, and a Juris Doctor graduate of Duke University School of Law, one of the premier law schools in the United States, if not the world. Well, you know what he's not putting down here? He's not putting down his, his class ranking. Like, with all of that, man, we'd expect you to be top in your class, right? Are you the gold medalist? No, he doesn't mention that. I'm sure he would have. What's your dick size, dude? Because you're giving us all this other relevant details. Like, I don't get what this guy's about, but so he goes on and on and on, and it just keeps going. Whoops, I'm just looking here. I was just trying to tag this. What are your thoughts on lawyers calling themselves QC prior to her death? QC is actually an earned honorific. It's now King's Counsel. It used to be Queen's Counsel. But you have to actually earn that to note that. Like, I'm not Queen's Counsel. I'm not King's Counsel. So I can't actually put that after my name. It's something where you've actually had to be recognized for it. So he goes on to make some other really exceptional claims. Mark Blount prides himself on his vast intellectual abilities. I'm sure you do, dude. I'm sure you do. And his ability to become an expert in any field of the law in an extremely short time span, often learning in 1 week doctrines that even experts in the respective fields fail to grasp. You know what I'm betting he can do in 1 week? I'm betting he can develop some Dunning-Kruger effect and think he's an expert in a field he is actually pretty crap at. That's my theory on this one, because a week is enough time to not actually necessarily get something, but to start thinking you are. So, Mark has practiced previously in the fields of zoning law, local government, condemnation defense, property law, corporate law, and constitutional law, and is well versed in these fields, though he's always excited by the opportunity to become an expert with respect to additional fields of law. Tell you what, dude, why don't you why don't you cure cancer, or build a rocket ship or something like that, given that you can, master all these things in a week. For the month of May, meetings with Mark Blount regarding new cases will be by appointment only. So if you want to hire one of the most intelligent attorneys and penetrating legal minds of this generation to handle your legal matter, please call his number to speak with Mark or to schedule an appointment. Wow. All right. So a lot of people figured that this must be a parody because holy crap, right? So, I mean, and the funniest thing about this, when I'm reading this, is I look at his 173 and I go, only? Like, you're doing this much dick waving over a 173? Okay, cool. It's a great score. But I got a 178. And he's pointing out that this is the 99.7th percentile. Let me do some math here. I see. Yeah, he could do all this in a week, but he got less than 180 on the LSAT. Yeah. If you're going to brag this much about your LSAT score, you better make sure it's a 180, because somebody out there is going to have a better score. So, he's got 0.3, and so let's see. Just doing some back of the napkin math, because I got a 178, which is the 99.98th percentile. So based on my back of the napkin math, for every 15 people who get his score, one gets my score. So, Mr. Blount, why'd you suck? Why couldn't you do better? Work harder. So, yeah, it gets worse. It gets so much worse. Because, yeah, this guy turns out to apparently be on Twitter, or somebody making fun of him. It could be somebody making fun of him. I don't know. So let's have a look at what he has to say on Twitter. So the Blount Law Firm, there's a picture. So, like, I don't know if that's him, but there's a picture there. It seems like the kind of picture you might pick if you wanted to make fun of that. And, scored a 173, the 99th percentile on the LSAT, okay, great. Graduated with a 3.51 GPA, so he wasn't top of his class. And you can see he's just going on and on about how he's such a great guy and so forth. He's got a lot of tweets that are posted all at the same time and not in a thread. It looks concerned there. What is it? So yeah, I don't know what's going on there. He's a weird guy. Oh wait, there's another picture of them saying, for all those who doubt that this is my real Twitter account. So All right. Now, you might be wondering, with a guy like this, surely he is an expert legal mind. He is able to do all the things that you can, that nobody else can. This guy is, he's got to be hot shit, right? So let's look at that, because this story just keeps getting better. So let's pull this up. Where do we have this? Here we go. All right. Here is a filing that he made in court. Like, this is a court document. He's filed this. So yeah. This is something that he submitted, and so let's have a look here. I see. Is he the ChatGPT lawyer? Oh God, no. He wrote this himself. If I was him, I'd be trying to claim that it. I'd be trying to claim that it was ChatGPT. So, Mark Jerome Johnson Blount, plaintiff, versus the United States of America, Merrick Garland, Attorney General of the United States, in his official and individual capacities, the Bureau of Alcohol, Tobacco, and Firearms and Explosives, an agency of the United States, and Bernard G. Hansen, special agent in charge of the Bureau of Alcohol, Tobacco, Firearms, and Explosives, Kansas City Field Division, in his official and individual capacities. So that's who he's suing. He's taken on the ATF, which I normally would approve of, right? Normally, that's exactly my bag. Complaint for declaratory judgment, injunctive relief, and attorney's fees. Now, I just want you guys to note something. I don't know if you can see it because it's real small print, but there's 189 pages of this. We're not going to go through it line by line, because there is 189 pages of this. Whew. And it begins with comes now. Now, you guys know how I feel about comes now as an intro. But this guy actually manages to do a worse intro by what he puts after that. Because normally I'm like, comes now. It sounds like a Victorian porno. It sounds like language that you should not use if you've ever, if you live in an era where your vehicle is not a horse. But yeah, plaintiff, or comes now, plaintiff Mark Jerome Johnson Blount, gentleman Esquire. So he's not just adding the Esquire, it's gentleman Esquire, Juris Doctor graduate of Duke University School of Law, and scorer of a 173, the 99th percentile on the law school admissions test, LSAT, and a 169.6, roughly the 95th percentile on the multi-state bar exam, MBA portion of the uniform bar exam, and praised that this court entered You don't bring up your LSAT in casual conversations as a lawyer. There's no need to bring it up at all. This is not something that I would put on my resume at this point in my career. But you certainly don't put it into a court filing. Ever. I mean, the only circumstance I could see where you would ever say what your LSAT score was in a court filing is if somehow it was relevant. I was applying to work at this law firm, and they discriminated against me based on my hair color. And, because of that, and then you might put in your LSAT score just to show that you are actually a viable candidate, but you wouldn't put it as the intro. But yeah, no, he files this with the court. You know what the court's going to think when they see this? They're going to go, what the actual F is wrong with you? So I see comes now is the required form in many jurisdictions, even if Runkle has rude thoughts about it. I know. That said, one of these days, if I ever become an eccentric billionaire, I will hire people to make the legal porno that's, it'll be called Comes Now, and it will be like Victorian whatever, and it will just be to make this really embarrassing, for everyone in the legal profession, to hopefully get them to stop doing that. So, and like, we'll make it a series. It'll be like, okay, Comes Now 37. It'll just be like a running series. So, yeah. All right. So let's sort of keep going here. So what is he looking to do? Well, he's asking for the court to declare that the National Firearms Act, the Gun Control Act of 1968, and the Firearms Owner Protection Act of 1986, and hereinafter collectively National Firearms Acts, are unconstitutional in that they infringe and deprive plaintiff of his ancient, inalienable, private, individual, absolute, ancestral, sovereign common law right to keep and bear arms, retained by his ancestors. Oh, this is going to be interesting. The founders of this country, and enumerated in the Second Amendment to the United States Constitution, by unconstitutionally prohibiting plaintiff from, what is it that he's upset that he's not allowed to do? What are they preventing him from doing that he can't do? Possessing machine guns of all descriptions manufactured after 1986, to wit, ordinary military weapons, and severely penalizing plaintiff for exercising this right, and that said acts are unconstitutional in that they violate the Commerce Clause of the United States Constitution, in that they attempt to regulate purely intrastate activities. And if you're asking this question, then you're asking one of the right questions. Wait. Did he just go sovereign citizen even as a lawyer? You bet he did. You bet he did. Yep. So, I mean, everybody knows I'm a gun guy. I'm in favor of taking on the government to get more firearm rights and so forth. But what this guy is likely to do, if anything, I mean, if this doesn't get thrown out on the basis of the court going, lol, bro, is that he'll get a ruling that hurts every other gun owner. So, don't like this at all. Don't like him. So, yeah. Let's sort of sample some of his theories, because we're not going to go line by line through 189 pages. Because 189 pages? Are you freaking kidding me? 100 and... it just baffles me. All right. So, he's going on about, this is just various jurisdiction and venue stuff, which we don't care about because it's just boring. So let's find the good stuff in here, because there's a whole bunch of really entertaining elements to it. Subject matter jurisdiction, you might be thinking back to Brooks. He's actually alleging that there is jurisdiction here, which is not, not the sort of Brooks argument, but it sounds like it. All right. So, standing to bring claim. Plaintiff has standing to bring this suit because plaintiff has incurred a particularized and concrete injury in fact to his ancient, inalienable, individual, private, ancestral common law right to keep and bear arms, as enumerated in the Second Amendment of the United States Constitution, but in no way reliant upon that document for its existence, due to defendant United States. And so you see what he's saying is he's saying, I don't need the Second Amendment here. This isn't a Second Amendment argument that he's making. I mean, there are some Second Amendment arguments that he makes in here, but he's saying that he's got a right to a machine gun, even absent the Second Amendment. Like, even if the Second Amendment was repealed tomorrow, he'd have a right to this, which, plaintiff plans on purchasing an M16 rifle, M4 rifle, squad automatic weapon, or other machine gun which comprises the standard issue equipment of a service member in the United States military, manufactured after 1987, to wit, an ordinary military weapon, or converting the AR-15 rifles that he already lawfully possesses to automatic weapons. Weapons which shoot, are designed to shoot, or can be readily restored to shoot automatically more than one shot without manual reloading by a single function of the trigger. To wit, the functional equivalents of M16 rifles, ordinary military weapons, and possessing said weapons in contravention to the National Firearms Acts in the immediate future. Yeah, and this is an important note here. I'm guessing his ancestors did not have machine guns. Certainly, they didn't have like a squad automatic weapon, I don't think. So when he converts his rifles to fully automatic weapons, they will be manufactured after 1987, which I think kind of, goes without saying. So why does he think that this is something that he gets to do? Well, and he notes here, this code section has been regularly enforced and violators are prosecuted fervently. A Cincinnati man was sentenced in U.S. District Court to 37 months in prison for illegally possessing a pistol that had been converted into an automatic weapon, which he used in self-defense during a shootout in a restaurant. And yeah, so he's citing an ATF news release. Okay, fair enough. I might have cited the court case, but he cites the news, like the press release. Fair enough. All right. Keeping on going here. Keeping on going. So he talks about the penalties. Let's get to your argument, sir. All right, where is your argument? Also, I've got I opened up the last jar of my nuclear beans. I'm kind of sad about that, although I'm happy that they're delicious. Ooh, and spicy. Ooh, I also need to show you guys my hot sauce today. That'll be fun. Oh, I have to go get a bottle of it. But all right. They say plaintiff is not required to actually violate these acts before having sufficient standing, as the National Firearms Acts are regularly enforced and carry severe penalties. So when an individual is subject to such a threat, an actual arrest, prosecution, or enforcement action is not a prerequisite to challenging the law. All right, well, he's saying that it's not necessary that he first expose himself to be able to challenge a statute that he claims deters the exercise of his rights. Fair ball. All right. Now, he's just going on a lot about standing, why he can bring this. Sovereign immunity, no bar, because the government is not acting within its agency relationship with the sovereign body, nor in accord with the sovereign authority vested in it by the sovereign body. This is going to sound fun, right? This is going to sound, yeah. So, sovereignty, sovereign power, and sovereign immunity. We're already getting nervous here, right? A sovereign is supreme in power, superior to all others, highest in power, chief independent of, etc. So, this is in order to be sovereign, one must be the person in which all power or rights and power originate, the one from whom all rights are derived. The government is in no way sovereign in relation to true Americans, the posterity, the lineal bloodline descendants of the founding generation, because our rights are not derived from the government or the Constitution for that matter, but instead are inherited and are derived from our lineal bloodline descent from our founding generation ancestors, the original sovereign body of this country, and the ones from whom the government derives its rights and powers. Do you see the argument he's making? he is making the argument that he gets special rights over other people, like over and above everyone else, because he himself is genetically, like, because he's inherited these rights. He's making an argument of basically that he is the king, and like, I feel like that is not how the U.S. works. That's not how that goes. So yeah. Now I'm just trying to find what is it? Find the other document here that is just exceptional. Like, this one is just standout amazing. So let's pull that up. All right. Hopefully everyone on the chat can see this, and we should zoom in so that we can see it and actually read it. This is Exhibit 1 to his filing. This is appended to his filing. This is now also a court document, right? So, family genealogy of the Blount family, the descent of Mark Jerome Johnson Blount the First from William Le Blount of Belton. So, 1, Mark Jerome Johnson Blount, that's him. We know this guy. 2, Alan Douglas Johnson at Moody Air Force Base, married Sharon Kathleen Rom, and had multiple kids. He's redacted the names of his siblings. His siblings are going to be very freaking happy about that. But he goes through the entire family tree here. So it just keeps going on. There are actually 29 pages of his genealogy, including like a payment voucher for services rendered. Various historical documents. So, yeah. This is exceptional levels of Crazy Town. But yeah, it ends with William Le Blount of Belton in Rutland. Okay. So basically, he's arguing something along the line of, like, this is my, like, I'm a lord of the United States. Yeah. So, he's basically saying, in this country, the government is in no way superior in power to the posterity, the lineal bloodline descendants of the founding generation, the sovereign body from which all sovereignty, governmental power, and legitimacy are derived. So, this is a sovereign citizen argument. It's a sov-cit argument, but it's a sov-cit argument that's a new and exciting sov-cit argument, because now he's arguing that he is a sovereign citizen by his birthright because his genealogy goes this far back. That is impressively dumb. It's like, it takes a whole lot of research and a whole lot of, so forth to come up with an argument this dumb. So, yeah. That's exceptional here. He notes, with respect to fundamental, inalienable, ancient, ancestral, unregulatable, uncontrollable individual rights, free Englishmen have always been individual sovereigns, as we are uncontrollable in the exercise of these rights so long as we are acting within the confines of these rights, and we derive these rights from none but our own ancestors. Thus, with respect to these rights, we free Englishmen are within our sovereign jurisdictions and are rightfully identified as the sovereign. The king was not the sovereign with respect to these rights, and thus outside his sovereign jurisdiction when he acted upon them. And he's, quoting English law from 1797, or an English article from 1797. I don't think the court's going to agree with this one. I don't think the court's going to go along with this and say, hey, yep, we think that this is lawful law. But this guy basically thinks he's royalty. And yeah, he thinks he's got more rights than your average person. We can go back to his Twitter and actually see this. It's, but yeah, he's talking about how he's 10th generation Georgian. He actually, he thinks that matters. Like, he thinks that that's a legal argument. Freaking crazy. So the posterity, not the government, is the sovereign. So basically, he's saying that he's got these special rights and special privileges that. So I suspect the court's going to tear this down, and it's going to be really entertaining to watch. Government sovereign immunity is derivative of the sovereign body's immunity. Only exists where government acting within the agency relationship it holds with the sovereign. Agency relationship. We're into sovereign citizen crazy town stuff again. They love this kind of stuff. And he claims to have studied law. He does. Yeah, posteriority. Nice. I like that one. This guy is, he's just, listen, people, he's a very special person and needs to have a machine gun. It is ridiculous here. So he keeps going on with this for a while there. It is bizarre. So, and he says, plaintiff's ancestors, members of the founding generation of this country, retained the sovereign power inherent in their right of keeping and bearing arms, and all other plenary sovereign power not specifically delegated to the government when they divested themselves of the limited, enumerated, and specified sovereign power enumerated as powers of the federal government in the Constitution. We're only at 39 pages in on Crazy Town, and I don't think he's actually cited a single United States law in his argument at this point. So, I mean, normally I would want to cite some case law here to say, like, hey, this is something that the courts have recognized maybe sometime in the last, 9 generations. Sometime. Yeah. So, carrying on here. There are certain fundamental rights which amount to sovereignty in the hands of the posterity. I'm going to have to be thinking posteriority. So, yeah, this just keeps on going. Basically, he's saying that he's got, these. Now, here's where we trigger the rule that I have, Runkle's rule. And that is, whoever cites the Magna Carta loses. Because here he's triggered Runkle's rule. Many of these ancient, inalienable, private, individual, ancestral sovereign rights were listed in the Magna Carta. Runkle's rule has been triggered. Whoever cites the Magna Carta loses. So, yeah. We'll see about this, but I think Mr. Blount might, if he finds out about this, he seems like the sort of guy to get big mad, and I bet that I'm not super concerned if this is the kind of argument he makes. So yeah, it just keeps on going. Like, And I mean, he doesn't just like specifically, or he doesn't just like offhand mention the Magna Carta. He keeps mentioning it over and over and over again. So talking about his free birthright. Oh, that sounds free men on the land-ish, doesn't it? So yeah, it just, let's see, how long does it take for him to actually cite a U.S. law? Thus, a noble woman or nobleman of England, who were noble by way of descent, possessing noble blood, retained their ancient, inalienable, private, individual, absolute ancestral right to a trial by jury of their peers, regardless of who they married, and this right could not be deprived or divested from them, much like the right to keep and bear arms cannot be deprived or divested from plaintiff, a member of the law-abiding posterity who inherited this absolute right from his arms-bearing ancestors. He's directly citing the nobility. And I'm looking at this. It does feel a little ChatGPT. ChatGPT would do a better job than this. Oh, man. So it just keeps going. I'm just trying to find if he actually gets to a U.S. law. Holy crap. We are at page 51, and he is citing a U.S. case. So he says that these rights are not granted by the Constitution, neither in any manner dependent upon that instrument for their existence, citing United States in Cruikshank, or v. Cruikshank of 1875. All right. So, now he says, it is only slaves that possess no ancient, inalienable, private, fundamental, absolute, individual, ancestral, sovereign rights within the chain of power, as only a slave has no absolute rights which the sovereign is bound to respect. This is why the status of slave usually goes hand in hand with the act of conquest. This, again, is sounding very much Freeman on the Land-ish. So now I'm just looking here. The present chain of power that is extant in America is the Anglo-American chain of power, a chain in which plaintiff and other members of the posterity comprise the present-day sovereign body. Plaintiff's ancestors comprised the sovereign body at the time of their founding up until the present. And even when the King of England was the recognized acting sovereign in the chain, a chain to which plaintiff's ancestors always possessed, etc., etc., etc. I'm just wondering if there's like a wee hint of racism in his whole discussion of, founding members versus slaves versus, I'm wondering about that one. That, I don't know at this point, but we shall see. So even if they had all that sovereign immunity, then, then they don't have enough, basically, is the summary of that. So once again, every founding father, every member of the body politic understand that the sovereign body of his country, oh God, he just keeps going on this one. He really is heavily citing this Edward Coke book from 1797. Now, I mean, I'm wondering if there's some sort of mental illness or what's going on with this guy. I can't speculate, really. But he does actually cite to the Magna Carta as well. This is the kind of document that might actually imperil his legal practice, right? This is the kind of thing where if I was the court receiving this, I would be concerned about his fitness to practice law. I would probably be referring this to the Law Society and being like, "Hey, what's going on?" Or to the Bar Association. Does this guy seem like the jerk from Good Will Hunting? No. The jerk from Good Will Hunting at least knew some things. This guy knows the opposite of things. This guy knows negative things. He has been he's managed to educate himself to be dumb. I see. Is this document public for non-lawyers? Yep. I found this. It's been posted online. It is. It's out there. People have been sharing this out. It is exceptional in its crazy town. It just keeps going on this whole sovereign citizen argument. For how many pages does he get to? Does he have an actual argument in here ever? He just keeps going. Congress has waived this. Okay, so he's saying that, yes, founded upon the Constitution. Cool. That at least might be vaguely something like an argument. So he's got his, he's arguing against the immunities from suit. He really needed to hire a different, a lawyer to help him. Because somebody to look over this to be like, wow, this is, So yeah, we're not going to go through all 189 pages because I feel like we will die of the brain worms will get into our skull, and we'll just our neurons will leak out through our ears, and yeah. Oh, here he's got an argument. Or plaintiff is a member of the posterity. He's going to establish this. Paragraphs 1 through 306 are realleged as if fully restated herein. Thank God he didn't feel like repeating them. Is he pro se or is he representing someone else? He is pro se. He's here representing himself. This is him. So the direct lineal bloodline descendants of the founding generation, the race that proceeds from a progenitor, offspring to the furthest generation, Ooh, that's getting real awkward. When he starts talking about race here, as I said, that's real awkward. So he's going through the descendants here. Plaintiff's ancestors always possessed the right to keep and bear arms. All the aforementioned branches of the Blount family of Soddington Hall were descended from a family of noble rank, and comprised and still comprise a part of the lower nobility, to wit the landed gentry and knightly class, and inherited the absolute, inalienable, private, ancestral right to keep and bear arms through the blood by way of their lineal, legal, and bloodline descent from their... You know what might actually be a result of this? A potential result of this case? He might actually get a court ruling that declares him to not be royalty and to not be nobility, which would be hilarious because he certainly thinks that he is Georgia nobility. So, as barons, peers of the realm, the Blount family of Mountjoy had offices and duties annexed to their dignities of great trust and confidence. Wow. Yeah, he's going on citing more noble families that he thinks, like, guys, I'm a Canadian. So tell me, does the U.S. recognize these noble titles? Oh, just he ought to be a gentleman of name and blood. So when he says that he's a gentleman esquire, he's talking about his nobility. Like he's saying that he's a noble when he says he's a gentleman esquire. Oh, Jesus. I should have saved this for after spicy time. I have some spicy time thoughts for this one. They are what and the. I'm sorry, I got to read this part here. It's so bad. As plaintiff's ancestors comprised the knightly class, who were entitled by virtue of their birth to keep and bear arms, as the right of keeping and bearing arms had always been an inalienable, private, individual, ancient, ancestral right held by them and their antecedents from time immemorial, plaintiff's ancestors were buried in tombs in the Church of St. Peter's Church in Astley, Worcestershire, or Worcester. You can mock me for that one. That's fair. That's deserved. Worcestershire, and the parish church of Kinlet, Shropshire, in St. John in the Baptist Church. He missed the T. It's Baptist, I think, but he says Baptist. Upon which rested effigies of said ancestors in full suits of armor and bearing swords, to wit, the ordinary military weapons of their day and age. Thus, even in death, plaintiff's ancestors bore arms. So Worcestershire. So is what people are telling me. So, yep. Being perennial warrior class nobles, plaintiffs' ancestors were not just entitled to keep and bear arms of military classification, but were expected to keep and bear such weapons for defense of the realm from both external and internal threats. Oh my God. I feel like it's important to remember here. We're going to come back to something. I'm just trying to see if I can. I can't switch to. Well, all right. Give me a second. I'm just going to go back to just remember something when he's talking about his, warrior nobility and so forth. This is his noble visage, folks. This is his noble visage. I mean, maybe if you were descended from the Habsburgs, dude. Tell us again how many loops there are in your family tree, because yeah, that's not. All right, carrying on. The common law right. Okay, is he actually going to talk about? So he says that there's a right for everybody to carry something. That's fantastic, but he's still saying that it belongs to the Magna Carta, which, again, Runkle's rule is you say the Magna Carta, you lose. It's just how that goes. Yeah. All right. Does he get to an actual argument at all, ever, in all of this? We're at 122 pages of skimming, looking for some sort of argument. Oh my God. What the hell? Persons of quality are in no danger of offending against this statute because our bearing of arms in public is no per se nuisance, not to the terror of anyone. Plaintiff's ancestors were in no danger of offending against the statute of Northampton, as they were ancestrally and personally part of the class of full rights holders of the common law right of keeping and bearing arms, to wit, persons of quality, who could not be subjected to regulation regarding their right to keep and bear arms. Okay. So once again, he says that he's a very special boy who's always had very special boy rights. And as a very special boy who has these very special boy rights, he gets to have a machine gun. Man, oh. Oh, So I was wondering if there was going to get to some like straight up racism in here, and here we go. Here we go. So while at common law, lords and esquires and their sons and persons whose yearly income from land amount to 100 pounds were of suitable condition to keep arms, with us every free white man is of suitable condition, and therefore every free white man may keep and bear arms. I'm just going to say, I wouldn't have quoted that in a filing. I would have had some sense to not quote that in a filing. Like, pick any other freaking case you want, but oh my God, no. Oh my God. All right, so yeah, this guy. Oh, wow. He's citing to Dred Scott. He is citing to Dred Scott. I'm pretty sure Dred Scott's not good law at this point, but as noted above, in America, as a common law, certain classes of persons did not possess the rights of keeping and bearing arms because they did not ancestrally descend from the class of rights holders. And in addition, in this country, they in no way comprise the body politic, the sovereign body. And he's citing to Dred Scott. I'm just gonna say here, this is real serious shit. Because when he's talking about certain classes of person, let me find a diagram for how we determined which class of person he's talking about. Because, yeah. Let me just find that right here. We've got our test for those certain classes of person. Yeah, that's what we're talking about. If you're wondering, like some people are saying, what is the Dred Scott decision? The Dred Scott decision is a giant embarrassment for the U.S. court system. And I say that not to like bash the U.S. court system, because every court system has come up with, with very stupid things. But Dred Scott was a decision which has, been long since overturned. But basically, Mr. Scott was trying to establish that he had the rights of an American citizen. And the difficulty he faced was that he was a black man. And the U.S. Supreme Court determined that that he was not a U.S. citizen because of that. And so now this particular decision is generally considered one of the worst ever decisions that the U.S. Supreme Court has ever issued. It is absolutely and entirely not good law. It is ridiculous to cite to it. Like, it is just absolutely ridiculous to cite to it. So Yeah, when he says here certain classes of persons did not possess the rights of keeping and bearing arms, and he cites to Dred Scott, that's specifically black people he's talking about. This is racist as Somebody's saying, what year was Dred Scott? Give me a second here while I pull that up. All right. So when was Dred Scott? Because, right, 1856. It's right in the case there. So, it's been overturned for a long time. So yeah, it's yeah. It is such a bad, you know, yeah, it is such a this is astoundingly nuts. Yeah, no, Dred Scott, Dred. Whew. All right, so that's the thing he puts in his writing here. That's the thing he puts in his writing. I see. Has he done anything worth getting his bar license revoked? I would be referring him for some bar scrutiny here from this filing. I would be suggesting that this says some things about his ability to to practice. Yeah. In the opinion of the court, which again citing Dred Scott, the legislation and histories of the times and the language used in the Declaration of Independence show that neither the class of persons who had been imported as slaves nor their descendants, whether they had become free or not, were then acknowledged as a part of the people, nor intended to be included in the general words used in that memorable instrument. Holy shit, dude! I'm sorry, we are not yet at spicy time, but holy crap! Yeah, Dred Scott is taught in law school as bad law, which Mr. LSAT clearly missed. Yeah, Dred Scott is basically taught as like, this is something that should never have happened, right? This is something that should never have happened. So, whew, so yeah, he's saying that he has more rights to guns than black people do. That's explicitly in his filings. Which he then goes on to talk about low-ranking persons. Wow. This guy is a complete sack of flaming garbage, and the bar association could do will do wonders if they remove him, because this is just nuts. This is just absolute crazy town, and whew. Well, yeah, I'm just gonna skip through just to see if he gets to anything resembling a point. He does get to the Constitution at page 158. 158 pages, guys, to get to the Constitution, which the U.S. Constitution is actually lawful law. So when we asked at the start how racist could he get, he said, "Hold my Confederate flag." All right, we're gonna need a palate cleanser after this one. I'm gonna have to go get something as a palate cleanser and maybe a scotch, because yeah. Oh, all right. Well, let me take a brief moment here. I'm gonna step back. I'm gonna go get some hot sauce. I'm gonna get something to try the hot sauce. This guy is gonna end up. I see this perhaps in years to come. This will be used as a what not to do in law school. I actually think that he may end up being held up in ethics classes as an example of like your ethical obligations. So all right, so I'm gonna throw on some some away from keyboard for just a moment here. I'm gonna go get some hot sauce. I'm gonna get a scotch. We're going to go through some super chats, and then we will talk, because we need something to get that out of our head. So, and there we go. All right. Oop, I got to turn off the noises. There we go. So, I see people had some comments on the music there. How did people like the away image there? I thought that was an amusing one of Goose attacking the computer. So, all right, let us do a swoop, because we need something to move past that. Swoop. See, as a non-American lawyer, I could argue this better. I feel like as a non-American lawyer, I could argue this better drunk and concussed. I think that all of us have argued this particular issue better than he has, in just by not filing anything. So I've got a little bit of scotch here, because yeah, it's we need something for that. So let's go through some super chats, some membership, because I am behind. So thank you to Rhineman YYC for 10 gifted memberships. Shima, thank you for the member chat there saying, I'll be asleep soon, but I'll be replay crew. Good night. Good night, Shima. Rabbit, thank you for 5 gifted memberships. Much appreciated. Paladin Phil, thank you for 10 gifted memberships. It's much appreciated as well. Angitoris, thank you for 10 gifted memberships. Much appreciated. Cookie Monster Steve, thank you for the member chat there. I'm descended from the first human, all power mine. Nice. Sin, thank you for 1 gifted membership. Much appreciated. And Lynn Britton, only good thing about this is he isn't from Alabama. I love that. All right, so let's look at some super chats here while we... So Michelle Doverspike, thank you for the membership. Much appreciated. Aqua, celebrating your and Mrs. Runkle's victory over the big spiny bastard with a London lemonade. Nice. Now, for people who don't sort of get this particular reference, we had this plant out front. It was a decorative plant, and it looked kind of neat, but it had burrs, and my wife decided she wanted it gone. And I said, okay, great. You say you want a plant gone, that plant is dead. So I go out and she says, be careful. This thing is spiny. It's got, I want it gone because I tried to, deal with it and it had spikes and I didn't like it. And I said, no big deal. So I went out and I hacked it up with my kukri. And so this thing. And in the process of that, it shed all sorts of little tiny needles all over me. And those needles then dug in. And so I had slivers all over. So, yeah, I finally went and ripped that up and dug it out and threw it out of the way. So the big spiny bastard is gone. In its place are blueberry bushes. So that I'm hoping they grow and turn into nice, something that is attractive in the front yard, and also something from which I can eat blueberries because I like blueberries. But yes, people saying listen to the wife, Runkle. Yeah. The wife was right on that one, and I really ought to have listened. So it's always more fun when the plants fight back. It is, unless that they're fighting back with spines, because I am still finding little spines in places, and it's just the last thing you want is to be continually finding slivers. Those suck and are not a lot of fun. Oops. Somebody was asking, you have bears in your neck of the woods, not in the city. There are bears around, but not in the city. All right. Gardener's gloves. I was wearing gloves. They spread like they were all over. It was getting in under my clothes. It was nasty. So yeah. All right, so let's look at next super chat here. Chicken Head PK Neely, Caesar. I'm always a fan of a Caesar. That's a great one. Cornell Customs Trains said, heard you were on the WHO list. I have no idea what that means, but I'm curious. I'm not sure if that's a shot or what, but I'm curious. Lindsay, Not sure if you saw on Friday, but I made the wrench that squirrel behind you has and promised a kilt for it. I did see that. Thank you, Lindsay. Our squirrel picked the fabric, so I'll send it up to you when I can get it finished. Well, thank you very much. If some people did notice that there's sort of another sort of thing there behind, I'll sort of pull that up here. So this little stuffed squirrel with, as you can see, it's got a wrench, or as they were calling a spanner in the in Scotland. But so I brought that back from Scotland. The people there sort of said, "Hey, we think you should have this." So it's a nice remembrance. The bird, these were at her service, and so I've clipped it on. I think I feel like squirrel needs a bird. So yeah. So there we go. All right. And I see Haley Mouse saying, I'm 8 weeks smoke free, addicted to knitting instead. That is a much better addiction. And so congratulations on that. It's if you can ever replace sort of a destructive habit with a constructive habit, that is that's an amazing way to go. So I approve 150%. Because I'm a big fan of like hobbies where you end up with something at the end of it, like the leather work. You end up with something at the end of it. You can't always be productive, but it's nice when you can be productive. So yeah. Donna Williams, thank you for the new membership. It's much appreciated. Skiamorph, these a-holes can be pretty manipulative and target vulnerable targets. Someone approached a friend in uni with a similar deal. Glad she was smart. Yep, absolutely. Why does Trudeau want Canadians to be victims of criminals by taking their right to defend their homes with firearms? My theory on that is that Trudeau has recognized that gun owners tend to vote not liberal, and is kind of hoping that if we have fewer gun owners, then those people will vote liberal instead. That's kind of my theory on that, is to try to break up a culture that it tends to vote not liberal. Trufflehound, posting LSAT score to substantiate legal competence is like posting childhood potty scores to just substantiate competence and using the dunny. Well done. I mean, it's just so ridiculous. It's yeah, I mean, I would have actually been more impressed if he posted his childhood potty stickers. What is the difference between a JD and an LLD? It really depends, because in Canada, they're or the LLB, they're kind of the same thing, but in different countries, they may have different status. So it can be chaotic in that sense. So I have an LLB, but I'm entitled to switch it over to a JD if I want to. Maybe I should. So yeah. That's just sort of an option there as to and the reason why you might want to do that is that in some countries you can get an LLB easier than a JD. So they might think it's a lesser degree, if that makes sense. All right. Yeah, I'm just dogs, rats, fish, cats became a YouTube member. Thank you very much. Welcome aboard. Sounds like the guy who tried to win an argument by reminding me he went to Harvard Law School. Yeah, I mean, anytime people try to pull rank like that, it's like, well, that's got to be embarrassing for Harvard, doesn't it? You're losing this argument. You have to try to bring them into it. Yeah. Comes now from Dookie University. That checks out, Dookie University. That's gonna make me smile. Maybe as a footnote, or somehow the need for it, professional expertise schooling. I mean, generally you shouldn't need to file that unless there's something relevant. LSAT, I'm a super slow reader with time limits. I can only get to half the questions. With no time limit, I can complete and get only 1 to 2 questions wrong. Are there study strategies other than increasing reading speed? I mean, reading speed is sadly part of it, but you can get better at reading efficiency. And what I mean by that is get better at picking the stuff out that you have to on the first read through. So that is that's a possibility. Truffle Hound saying, I'm breaking out. I'm allergic to pomposity. Fair enough. That's there's a lot of it in this. Crazy Cat Queen, his delusions of grandeur make me want to wrap him up in a nice, comfy, white, huggy shirt so someone can evaluate him. I think I know what kind of huggy shirt you mean. So how pure is his bloodline? Habsburg pure? Looking at the picture of him, I wonder if there aren't some loops in it and some a lot of sort of circular shapes in that in that thing there. I'm just tagging some of the chats here just to respond to. Oh my God, face purple smiling tears. He shouldn't be his own lawyer, but hey, where do you get a colleague with such a high SAT? I mean, the guy is not doing a great job there. Jesse St. John became a member, much appreciated, and then follows it up with a super chat saying, sorry, Runkle, I thought I was already a member, but I guess it slipped through somehow. I've been watching you and Rob since Depp. You, sir, are good people, and I love supporting good people. Well, thank you very much. I hope I never let you down on that, but thank you. M169 for $5 there. Tell me you shouldn't have weapons without telling me you shouldn't. Good grief. No kidding, right? It's this guy is concerning in various ways. So, yo, I'm offended. The Family Guy didn't include a yellow category, and my birth certificate clearly says my face is white yellow. 1967 from Florida. Well, fair enough. And I see Truffle Hound saying, hang on. When citing case law, we were taught to review cases firstly for relevance and then for currency. This is imbecilic if it's not a parody misfire. I mean, nobody writes 189 pages as a parody and then files it under their own name. Like, so Ohio Palm Mom, thank you for losing the bathroom picture. Talking about my away from keyboard picture. Yeah, some people didn't like it, so we got this instead. I think it's a good one. Scary how barren Alberta grocery store shelves are. Went to a No Frills in Calgary. There was no salt, almost no flour, little sugar, not much butter either. Thoughts? There still seems to be supply chain issues, and also I think a lot of people, because inflation has been getting to be a problem, a lot of people are going back to trying to make make bread, make this sort of thing, and yeah. Runkle, we would like to see a grad pic from law school. I gotta see if I can find one. I'm not big on pictures overall, so I thought it was against the law for you to use a gun to protect your property in Canada. It's complicated, is the answer to that one. And Glock, thank you very much for the dollar there. Thank you, much appreciated. Aaron E saying, I took up pressure canning. That is a great thing. I just also got to I remember that I forgot to cover something in this case. So we got to go back to the case. I'm sorry, folks. We're going to do a swoop as we go back, but we're going to go back for just one thing. All right. So let's go back for a moment to the case because, yeah. Attorney's fees. So paragraphs 1 through 485 are realleged as is specifically restated herein. Aren't we glad that he didn't go and type those paragraphs up again? He basically says that these laws were passed under the color of law and enforced by defendants under the color of law in bad faith with the impermissible, unconstitutional intent of depriving him of his rights by preventing him from possessing machine guns. There's lots of people who I got no issue with having machine guns. lots of people, but this guy wouldn't trust with string or, paint. So while plaintiff proceeds pro se in this action, plaintiff is a lawyer, a graduate of Duke University School of Law, and a scorer of a 173, the 99th percentile on the LSAT, and a 169.6 on the multi-state bar exam portion of the uniform bar exam, and a 169 on the MBA portion of the Georgia bar exam. So going on about that. As such, plaintiff's time is extremely valuable. Plaintiff charging between $300 and $500 per billable hour for work that he completes for clients as a private practice attorney. Now, I think that his time might be expensive, because he's saying he charges $300 to $500. But valuable? I'm not sure I'm seeing valuable here. I'm seeing just expensive. I am seeing that maybe his time is not so valuable. As plaintiff is one of the most intelligent attorneys in this country, sir, I encourage you not to put that into an affidavit, because swearing a false affidavit can get you into a lot of trouble. And one of the most competent attorneys in this field of law. Again, you really, really need to not put this into an affidavit. Swearing a false affidavit, not so great. Plaintiff should be allowed to collect attorney's fees in connection with his self-representation in this case, as the very intent of 28 U.S.C. 2412B is to enable United States citizens to vindicate their rights when such said rights are unconstitutionally infringed. Plaintiff has spent hundreds of hours drafting this complaint and researching the law so that he may effectively vindicate his right to keep and bear arms before the court. Now, let's just pull this up. 28 U.S.C. 2412B. Because as I recall, this is itself interesting. 28 U.S.C. 2412B. What do we get? Oh, we get a CAPTCHA, because, of course, Google's been doing this thing where they throw CAPTCHAs at me nonstop, and I don't like it. Here we go. U.S. code. I'm just looking here because just looking there. I believe there's a provision about pro se. Just trying to pull this up here. Give me a second as we drag this over. And I'm going to switch our screens up. Here we go. All right. Now, from my understanding, pro ses are prohibited from getting attorney's fees under these provisions. So, yeah. I'm just trying to see here. Parties seeking fees and expenses have to show that they actually paid those fees and expenses. Yep. Just trying to see here. Is the pro se attorney entitled to attorney's fees? This is an article we've got right here. So, as the special situation of a lawyer representing himself, does he get fees? I don't think he's going to get fees on this one, partially because I don't think he's going to get any judgment in his favor. Like this, even his page count is higher than his LSAT score. If he was one of the most intelligent attorneys in the country, he would have been recruited. He is working for himself. I mean, if he was one of the most intelligent attorneys in the country, you would think he would know not to cite to Dred Scott. Like, this is literally parody land. Yeah. All right, let's swoop and move on to something else. All right, so we're not yet at the spice must flow time, but we can still be at this time. All right, because I have some hot sauce. Now, I forgot to grab the video here that was me taste testing the hot sauce. So I'm just trying to figure out which day that was from to see if I can pull that up here somehow. So, yeah, because I've got some hot sauce taste testing. I'm just trying to see if I can actually track it down. The original taste test. I don't know that I can. Yeah. I'm trying to find the right shirt that I was wearing. I may have lost that. It is what it is. All right. So, I see. Am I flogging this sauce? Yes, eventually. I can't sell the sauce yet because I can't sell the sauce yet because I don't yet have all of the labeling done. But I'm working on the labeling. So let me show you one of the designs of my labels. So I'm just going to pull that up here on, I can show you guys on Canva where I'm, all right. So this is my rough design for the label. I haven't yet finished, I haven't yet finished the label here, but this is one of the label designs. So, you know, we've got our title here, which is Everyone Makes Mistakes, which I think is entertaining. And we've got our nutrition facts, which is required. I can't sell this either within or outside of Canada without the nutrition facts. So I posted that I needed the NFT. This is my nutrition facts table. It's the only NFT worth having. But yeah. So this tells us what the ingredients are, tells us our vital, our elements of vital things, like that it contains 0% of your daily requirement of potassium, 0% of your daily, cholesterol, 0% of your fibers and sugars and fats and so forth, because it's hot sauce, people. You really ought not to be eating hot sauce as like a food. But yeah, this is per 1 teaspoon. I also don't recommend that you just swallow an entire teaspoon of the hot sauce. I might, but for most people, that would be a bad idea. All right. I haven't yet worked out the text that's going to be on it, but it will include some critical things because need it to be in French too. Yep, hence why it's ingredients and then ingredients. I also need to see about, I may try to get it capsaicin tested, because if I can get it capsaicin tested, then I can say what its Scoville rating is, because right now I don't know. It's just spicy. But yeah, this is kind of my label design. So once I've got all of this determined, I'm going to get some, some labels. Now, I've got some of my hot sauce here. I've got 2 bottles of it. And one of them, my label or my little marking on it is smudged. So this is my regular strength. And my regular strength hot sauce is basically habanero based. And then I've got my stronger hot sauce, which is has some Carolina Reapers added to it. So I promised that I would do some taste testing here. All right. Now I see somebody who's saying, because I did a video of my first taste, and I'm just trying to see if I can track it down here. All right, I may have tracked it down. We'll have to see. Just seeing here. All right, do people want to see? I'll do some testing on screen, but I'm gonna also just play for you guys the my first try. So let me just pull that up here. I found it in my queue. So I just took delivery of the hot sauces I had made. Now, can you guys hear that? Are you able to hear that? Hear the video? Hopefully. All right, we're gonna run it. And so I'm gonna video myself trying them. I haven't tried these yet. I'm kind of excited, kind of apprehensive. Okay, I see people saying more volume. It's at maximum volume. So I'm gonna give me a second. I'm gonna do I'm gonna do a bit of an edit here, just real fast, just so I can up the volume of it. We're just gonna take this down. I'm just going to do a real quick edit. Just to throw some additional volume on it, just so I can, because I see people saying that they can barely hear it. So let me just, as fast as I can, edit it. All right. Sorry, it'll just be a quick second. See people saying there's a little setting called volume. I'm trying not to be, mean to my listeners here. Don't change. All right. Totally random, but I just finished darning 2 socks. Mended 4 pockets in my PJs, and mended 4 pupper toys. I can't mend the pupper toys in my house because the time I discover that the puppers have got them, one pup doesn't destroy them, but the other pup just absolutely nukes them. So there's not a whole lot I can do about that. All right. Add to render queue. Let's rendering. We'll just see how this goes. Hopefully it'll render fast enough that, yeah. I know Runkle has the Magna Carta rule, but SCOTUS did cite it last week. I mean, if the court cites it, that's one thing, but usually the party's citing it. I'll have to check that out and see that one. I see people saying huge lag spike. No, that's because I'm rendering. Give me 1 second. It'll just be a moment. Also, while we wait, we are at this time. Technically, we are about 20 seconds off, but we're almost there. So, yes, I can tell the HOA story. There were some people who were asking about the HOA story. Now, it's not really technically an HOA because it was a condo board. The condo board, but they basically do the same thing. So the condo board had all sorts of rules. And one of the rules that they had was that you couldn't have anything in your window that was not white or tan. And so the idea for this was that you could only have, you couldn't have drapes that were blue or purple or whatever else. That was silly. However, because of that, we had I like to keep weird hours. I still do, but I especially liked to keep weird hours at that point. And so my weird hours included sleeping until, 2 in the afternoon. And so I wanted to tinfoil the windows for my room. Now, my room at the time was in a recess. You had to act, because it was in like this pit, basically, in order to actually see the windows of my room. You had to be right up next to you had to be in the yard. Nevertheless, somebody complained as soon as I tinfoiled the windows. And so the question was, how did they know that this had been done? Because, yeah. But regardless, they complained. So I took the tinfoil down, and then I put up paper. I put white paper over the windows. And then on the inside of the white paper, I put tinfoil. But it was all from outside. All you could see was the window was now white instead of silver. So the condo board, or the townhouse board there, were like, we need to inspect to make sure that the windows are not tinfoiled, because even though it's white from the outside, now we need to make sure that there's not tinfoil on the inside. To which we were going like, why? This is none of your business. But they were like, no, you can't put anything like that in the window. So my mom was not super pleased by this. And so we were in a bit of a dispute with them. And they kept sending these like old ladies to like give us grief over this. It'd be like, hey, why have you not, let us look? So finally, Mom outsmarted them. And the way she did that was, when one of the old ladies came there, she said, hey, we already let somebody else look. We already let, that other lady look. And they're like, which one? She's like, I don't know her name, but that other person already came in and checked and said we're fine. And then once that happened, they got into infighting, because it was like, somebody has checked, and they never came back because they could never figure out who it was who had actually done the check. And the reason why they couldn't figure out who it was who'd done the check was because nobody had done the check, but we just wanted them to go away. So that worked out quite nicely, and that was our sort of little battle with the condo board there. They get ridiculous, but all right, let's watch this. I think I've turned up the volume on this. Hopefully we can. I just took delivery of the hot sauces I had made, and so I'm gonna video myself trying them. All right, we need a swoop for this, and this is the appropriate swoop. So this, we're watching a video. This was the first time that I had ever tried the hot sauce. So this is, I could show you guys me having some right now on screen, and I probably will, but this I wanted to capture the first time. And you can see where I slashed myself shaving. So that's embarrassing. I haven't tried these yet. I'm kind of excited, kind of apprehensive. This is the sort of default level. It's just, and I don't have labels for them yet. So you can just see it's got a really nice color to it. And I also got a spicier level. And so because they don't have labels, I drew a little X on it. And then I drew a happy little face over top of that, just to let me know which one was which. Okay, so let's give these a go. I've got some chopsticks here that I'm just going to dip into them to try it out. And so, all right. So I've got a little sample here. That's got some spice to it, and that's the regular level. Um, it's not murdering me, but it's definitely got some spice to it. I'm gonna have to use this with caution, but it's got I like the taste. It's not vinegary; it's a fermented sauce. It's habanero sort of forward. Yeah, I really like this. There's some depth to it because it's got some onion in there. Um, I'm going to use this on all sorts of things. I made an original hot sauce, and this is kind of based on that one. I originally made the hot sauce as sort of, and this tastes pretty much exactly like my original. So I'm really happy with this. Yeah, I'm gonna be really happy with this one. All right. So doing that up now, as I said, that first one was pretty spicy, and now the second one is far more spicy. I hope, or I expect, because this one is loaded with Reapers. So Carolina Reapers are also in this one. So we're just gonna do a little dip here. Um, I'm just gonna give myself a moment, maybe 1 second. I'm just going to grab something to rinse my mouth out, just because I'm still feeling the first one. All right, so I'm going to do a quick sort of rinse. All right, there we go. And now let's try this one. I'm feeling a little bit nervous, I will say. I like the flavor of it. Whew. Got some, yep, this one's got some potency to it. Um, I'm not sort of a hot sauce sommelier, so I can't really describe the flavor in full detail, but whew. Yeah, you're gonna want to use this with some caution. But it is a really good flavor. So, mm, little bit of sweetness on the sort of back end of it. Yeah, I like these. So, I'm really thrilled because I was worried that these would not taste good, and instead they are both really good sauces. So, regular strength, extra strength, and I guess next thing I got to do is make labels for them and get them shipped out. I'm feeling pretty pleased, I got to say. Ooh, yeah, that's that second one's got some bite. All right, so that's now somebody was saying, did you make these? I didn't make them. I made the so way back when I made some hot sauce in my garage, just with a like a fermenter, and I really like the hot sauce, and I'm running out of it. And so, but I have been talking about how I like the hot sauce. And so somebody reached out and was like, hey, a friend of mine is going into business running a fermenting company. Maybe you should talk to him about setting up a hot sauce, like making a hot sauce. And I went, hell yes, that sounds like a great idea. So his company is Lessig Ferments. It he's a chef. He's gone into sort of business there, and so I sort of reached out to this guy and said, hey, let's talk about, can we make a hot sauce? And he was like, yeah, we can do that. So I sent him. I didn't have a recipe. What I had was a picture of the ingredients that I used to make the hot sauce the first time. Because rather than doing a recipe, I just kind of laid them out on a sheet and took a picture. I was like, that's the best I'm going to do right now is just, you know, is just take that picture. So I sent that to him, and he was like, "Yep, we can do that." And he said, "I'll draft up a recipe." He did a little bit of tinkering. There's some stuff in the ingredient list on this one that wasn't in my original, like what do you call it? Apple cider vinegar wasn't in the original, but the apple cider vinegar doesn't give it like a vinegar flavor. It's still a fermented pepper flavor. There's no extracts in this. There's no sort of chemical aftertaste to it. So this is very much a natural tasting. And I mean, I'm not one of these sort of like big on everything's got to be super this isn't sort of like some hippie perspective on things. It's just that hot sauces that use like artificial or added capsaicin tend to have a very sort of chemically taste to them, and so that's kind of how those go. So yeah, I was basically just like, hey, let's do this. So he got started. He got all of this going, and I was just like, I was worried, I will say, because you go and you start in on something like that, and you're going like, is it gonna be good or is it gonna be not good? So you don't know until you actually get delivery of this stuff, and so I got like 140 bottles or something like that. And, when you're taking 140 bottles of delivery of stuff, it's kind of nerve wracking. But this is very, very close to the taste of my original. And I really, I like it. And if you're wondering how much I like it, today I actually, like this bottle here, I actually took to the office and had like this. I put this in my sandwich at lunch. So it's that's kind of sort of how this sauce came to be. And so now I've got a bunch of these things. I'm going to try to get them ready to sort of sell off here. Just so now the hotter one is it's got a bit of a different flavor profile, but it is hot. It's very hot. So Sin is asking, is that his hot sauce? It is. It's quite spicy. So yeah. Now I also have a bag of hot sauce. So I've got to go buy more woozy bottles because that's what these little bottles are called. They're called a woozy bottle. So I got to go buy more of those and then fill those. And so that's my first design for a label is this one. The everyone makes mistakes. I think that's sort of a fun label there. And then the second design I have, I'm just going to see if I can bring it up here on my now this is sort of a mock-up. I haven't put the proper NFT label on it yet or anything like that, but this is my second sort of mock-up, is the Burn Your Regrets label. Burn Your Regrets is the second one on that one. So and I see Koru is saying, never thought to make a label. In order to sell them in Canada, I have to I have to have a label on them. So that it's got to have a label with the ingredients and so forth. So that's required. I'm thinking this one for the spicier one, and the everyone makes mistakes for the other. Yeah, likely safe, unrefrigerated until it's opened. I mean, it's hot sauce. It's shelf stable. These things actually should be fine left on a shelf. Hot sauce will take a long time to go bad, but I can't say for certain. That said, I'm not required to put put labels on all of that because it's just or to put like instructions on all of that. You're only required if you've got sort of special requirements. And I see we've got the Alberta, polls are starting to come in. So West Yellowhead is, we've got NDP leaning. The, what do you call it? The UCP is leading in sort of the expected places. Where things are going to start to matter is in like Edmonton, and Calgary is going to be sort of the big hotbed battlegrounds. So yeah, this is sort of my design there. I secretly assumed you'd call the hotter one F around and find out. The problem is that you can get into some trouble putting swear words as the labels on things. What color am I hoping to win? Neither. I don't like either of them. So yeah, I'm not a huge fan of either of the parties, but they're both awful in various ways. So that is what it is. Are these Mid-Journey graphics? Yep. I'm trying to keep these inexpensive. I don't have an art budget, so the alternative on that would be like just some stock image of chili peppers, which I didn't really want to do on that. Cursey words are a no for commercial products. Yep, absolutely. So it's going to be interesting. Rideman YYC is asking, where's the French? If you look at, I'll pull up the other design here just and I can show you sort of the French aspects of it. So present, share screen. So I'm only required to have certain things in French. So if you look at the nutrition facts over here, you can see nutrition facts, valeur nutritive. So all of this box is in English and in French. Hot sauce / sauce piquante, that is also French English. The title of it, I'm not required to translate. The title of it is I can just have as is. So if you're wondering what the French version is, the French version is everyone makes mistakes. Similarly, like pointless flavor text, I am not required to translate. So the whole like this, and this is, I haven't decided on all of this. There's a few elements that I'm definitely keeping, but I'm not required to have this stuff in French. So I am going to harmonize the font. Somebody was saying that. Yeah. I've been working on this label. I haven't yet worked on adding things to the other label, but yeah. Tout le monde fait des erreurs. I mean, it just doesn't have the same aspect. So it's just going to be as is in the French. Like this is as it is. I can't read either label because of font size and spacing. I'm hoping it'll be legible. I'm going to do like a test print and just try to make sure that it is actually legible on a bottle. So I just have to see that sort of once I see how it looks when I print. So I just will have to see and sort of figure that one out. But I'm hoping it'll go. I see people saying we can't read it because it's small on the screen. I mean, it's going to be small on the label too, but I mean, typically with a product label, you're going to bring it up close to your face, right? So, yeah, it's I'm messing with buttons here as I so I mean, I just this is an experiment. I'm proud of what this all is, but yeah, and I see somebody made a reference. I'm just pulling it up here, just if I can find it in the chat. To what is it? Did you ever hear of Pink Sauce from TikTok? She did everything wrong to sell a sauce. Yeah, the Pink Sauce thing has all sorts of problems. This I'm hoping is not going to be Pink Sauce because, yeah, I mean, Pink Sauce, amongst other things, was apparently not shelf stable, and you know yeah, it that was a bit of a concern. Hopefully, like, this stuff should be shelf stable. Like, if I just what do you call it, if I just ship this in the mail, it should be no problem. It's also perfect timing because we're getting away from winter, so I don't need to worry about this freezing if it goes in the if it goes in the mail. Andrea Laws, can I put in a pre-order? I don't have an ordering site yet. And will you ship to New Zealand? I'm going to have to look into where I can ship because, like, I don't know what New Zealand's food rules are for importing, foods to New Zealand. Um, so, like, I don't know. Every country has different labels and so forth. So, I don't know what they're going to specify on that. I'm going to have to do some looking because I know there's a bunch of people in a bunch of different countries. So it looks like, I'll have to just sort of see what's going on there. So it might be different if I'm shipping like one versus if I'm shipping lots, but I'm going to have to figure all this out. It is what it is. So I see some suggestions for sauce, Lago sauce. Maybe not. I like that, but yeah, I'm planning on shipping some out as soon as I can. The U.S. To get it into the U.S., I have to make an application to get an exemption from their food labeling rules, because their food labeling rules, they need a different label than the Canadian label. And so I don't really want to have labels for every different country at this point. So I'm just going to try to see. But apparently the U.S. allows me to get an exemption if I get if I'm selling under $500,000 worth of product in a year, then I'm allowed to, then I can get that exception. So, yeah, and I see some people saying, I would love to support in buying, but I can't even stand sriracha. I would recommend not using this if you can't stand sriracha. This is spicier than sriracha. I can say I was doing like a taste test with one of my favorite hot sauces, the Bravado Black Garlic. The Bravado Black Garlic. I can just sort of pull this down. You can see it marks itself as having 5 flames on it. It is it's the same sort of, or it's the similar spice level as my sort of basic level. Do I know the price point yet? I don't have all my expenses in yet. I'm hoping somewhere. I got to figure out the math on like how much it costs to mail them and so forth. I may just say plus shipping, but yeah, I will probably include. I'll probably try to figure it out. It should be under $20. That's my hope. If it ends up being more than that, I'm going to call this a tremendous failure. So I'm going to keep those costs as low as I can. So, but that's sort of what we're what we're going to see there. So we'll figure that all out. I'm still working on getting all my compliance and all of that done. But yeah, do you have to pay a Canadian sales tax or equivalent? I have to pay GST on all of this, and which means I got to pass GST on. So at least for the Canadian sales. So fun times. All right. So just looking here. Bring it to a farmer's market in Cumbria. That might be a little bit distant. All right, so let's do a swoop here. As I said, I'm really happy with my hot sauce. I'm really, I'm feeling pretty proud of it. I'm gonna pull a number of bottles aside for myself, which I feel is a sign of a good hot sauce, right? If this wasn't something that I was willing to, if this wasn't something that I liked on my own food, I wouldn't sell it to you guys. So I just was like, yeah, we're just going to uh, I I've ordered merch as test merch, and then just gone like, this is not not sufficient, like not good enough, and yeah. Um, James Randolph, food items are taxed in Canada. That's a good point. It might actually be GST exempt. So that would be a good thought. Have you considered smoking your peppers before you make the sauce for a smoky hot sauce? I have some. I don't know if I can give away all the secrets as to the process here. Are you going to send Rob some so you guys can do wing roulette? I am going to send Rob some. Rob is going to get some. And I see send some to Sean at Hot Ones. I'm sure that Sean at Hot Ones gets a ton of hot sauces, but the other problem is that if, like, let's say they said, hey, we want to do this as a Hot Ones hot sauce. The problem is I don't have enough to actually, stock their that kind of demand. So, I mean, maybe I'll reach out and say like, hey, would you like a sample bottle? But if he was like, hey, we would love to include this in a season, then I'd have to talk to my fermentation guy and be like, we need to make lots of this now. And that would be a lovely problem to have. But yeah. So I'm looking forward to this. I'm really excited about this. I think it's this is not sort of something that I sort of thought about as like a big kind of like, this is a life goal, but it is really nice to be able to be like, hey, it's just a really cool thing to be able to do, to share with you guys. So yeah. Hey Runkle, what are we chatting about? We're chatting about my own style of hot sauce that I've had made here, and based on sort of my design there. So all right, question: does Kickstarter work for foodstuffs? I don't actually know. That is a good question. Was the turnaround long? A few months. So we'll have to see. We'll have to sort of see on that one. But yeah, we'll figure all that out. All right, let's do a swoop and then cover some super chats, and then we've got some more entertaining tales of legal effery. Whoop. And I love this. You're very creative, and I know this is going to be a very hot item on the market. Nice. So, and I see somebody saying Tammy Dunn is a great food review YouTube channel that would give a fair review of the sauces. That's not a bad thought. Yeah, and fermentation does take a while. That's part of the delay on all of this. Morgan 908. I had flashbacks to the time I was attacked by a something in Ireland. It was overall a good trip, though. All good, but those things have pointy, nasty teeth. Might be was that a squirrel? Must be a squirrel. So wait, did you make the hot sauce or someone else? It was made by Lessig Ferments on behalf of Runkle of the Bailey Limited. So that's why it's going to say Runkle of the Bailey Limited on the package there. Well, Well, now I'm super excited to try the hot sauce. I hope I don't miss the release. The more you describe it, the more I want to get. Haha. I hope people like it too. I like it. I hope others do as well. This makes me sad that I'm allergic to capsaicin. I am sorry to hear that. I love capsaicin, but it doesn't work for everyone. I figured a leather crafter would make a leather-laced bottle corset for a label. Oh, that's actually not a bad idea to make like a certain number of like limited edition that come with like a little leather holster or something. So that's not a bad idea. Can I put in a pre-order and will you ship to New Zealand? As I said, I don't have yet. I don't have an order system set up yet. I got to get that going, and then I will have to figure out where I can ship it. So yeah. And hot sauce made by a hot sauce lover for hot sauce lovers. It's a passion project. I dig it. Yep. It was just one of those things where it's just like, oh my God, this is such a cool opportunity to make a hot sauce that I was just like, yeah. And I already have a recipe. Let's do it. So I was excited by that. So, all right, let's do a swoop and then cover our next tale. I cut myself off. Tale of woe. All right. So lots of people have been reading in the news about ChatGPT being used in court and how it went amazingly. No, wait, it went real badly. So let's talk about that because it is exciting as to just how this goes. So yeah, this is real bad. Now I'm just trying to see here the now I'm just trying to find the starting point on all of this one because it is this one is really an exceptional story, and by exceptional I don't mean in a good way. I mean that this one is just astounding as to how this ends up going. So it's a real baffling sort of case. So I'm just trying to find the original here. Just where this all starts. Yeah. All right. Sorry about all of this. I'm just trying to track the original document down. Because sorry, this is where did this go? Where did this end up going? I had this right here, but now there's so many documents on this filing, and now I'm just trying to find it. It is frustrating on all of this. All right. So I'm just looking at all of this here, just trying to track this down. So that's the reply. Where's the actual document? Where's the document they're responding to? All right. Peter DeLuca. Where's this? Where's his actual memorandum? It's not here, apparently. So that's the reply memorandum. Where's the actual memorandum? Affirmation, exhibit, motion for extension of time. All right. Do we have... Yeah, where is the... Sorry, folks. I am off my... I see people saying this is why legal... Where is it in this list of stuff? This is annoying. All right. I guess we'll start off with the reply memorandum just because I can find that right now. So we'll start with that. So let's just see. There we go. There we go. All right. Sorry about the fumbling around there. So what's going on here is you've got Mata suing Avianca Incorporated, and the defendants are making a motion to dismiss plaintiff's verified complaint. Actually, let me open this up in, what is it? We'll just open this up a different way here. And stop screen, present, share screen. There we go. All right. So reply memorandum in support of the of all of this. So, and this is basically because this reply memorandum is in response to a document that they get that they find to be very odd. And so the this document is a memorandum in support of a motion. I'm just trying to see here. Is this the one that's got... Just trying to... The original document is chaotic. All right. So what we'll see here in terms of all of this is they'll have some entertaining aspects. So they say plaintiff does not dispute that this action is governed by the Montreal Convention, which is regarding to airlines. And plaintiff has not cited any existing authority holding that the bankruptcy code tolls the 2-year limitations period, or that New York law supplies the relevant statute of limitations. So tolls the limitation is basically just saying that the limitation period is held up. They've got a limitation period at this point. So there's a limitation issue. I see, am I looking for document 21? I might well be looking for document 21. I think I am, but I'm just trying to see here. Exhibit C, nope. So there's the affirmation. Yes, this is the one I am looking for. All right. I think. All right, let's back up here, and I will just start this at the beginning. And thank you very much for the person who sort of pointed that out there. Yeah. Here we go. All right, sorry about all that. All right, so affirmation in opposition. I, Peter Loduca, declare as follows. And he submits this affirmation in opposition to defendants' motion to dismiss for failure to state a claim upon which relief may be granted. So basically what's happening is that Avianca is asking for Robert Mata's complaint to be thrown out. He wants it to be tossed. And I just want to note here, Mr. Mata is blameless in this. This is not his fault, right? This is not his, his fault here. But this is a lawsuit that's going on between Roberta Mata. Oh, sorry, Roberta would be a Ms. Mata and Avianca. So they're suing over something, and Avianca wants this to be thrown out. So this is a filing that was submitted, right? And basically, they say this claim for personal injuries arises out of plaintiff having been injured on August 27th, 2019, when struck by a metal serving cart by an employee of defendant Avianca while a passenger on Flight 670 traveling from El Salvador to New York. So I don't know what kind of injuries she struck, but or suffered, but she was struck by a cart. That's why she's suing. Okay. And they say was struck on the left knee by a metal snack drink cart and suffering serious injuries. Does it say what the serious injuries are? We don't know. But there are issues of limitation periods. There are various, sorts of these kinds of things. And you'll just note here that they start citing, various case law. And so state courts have concurrent jurisdiction over claims arising out of international airline incidents under the Montreal Convention, and plaintiff was well within his rights to commence this timely action in state court. And so they start citing some cases. So both federal and state courts alike have continually held that the Montreal Convention does not preempt state law remedies and that plaintiffs are entitled to choose the forum in which to bring their claim. In Shaboon and Egypt Air, or Shaboon v. Egypt Air, the Illinois Appellate Court held that state courts have concurrent jurisdiction over claims arising out of an international airline incident under the Montreal Convention, and that the plaintiff was not required to bring their claim in federal court. The court noted that the Montreal Convention allows for jurisdiction to be established in the courts of the country where the plaintiff has their domicile or principal place of business, and that the plaintiff has satisfied this requirement by filing their claim in state court in Illinois. Next, in Peterson v. Iran Air, there's more details. In Ehrlich v. American Airlines, held that state courts have jurisdiction over claims arising out of an international airline incident, and the plaintiff was not required to bring their claim in federal court. In Martinez v. Delta Airlines, brought a negligence claim against Delta Airlines in state court for injuries. The state of Durden v. KLM Royal Dutch Airlines, brought a wrongful death claim, etc., etc., etc. We see this, the United States Court of Appeal for the 11th Circuit specifically addresses the effect of a bankruptcy stay under the Montreal Convention in the case of Varghese v. China Southern Airlines, stating that appellants argue that the district court erred in dismissing their claims as untimely. They assert that the limitations period under the Montreal Convention was told during the pendency of the bankruptcy court proceedings. We agree. The Bankruptcy Code provides that the filing of a bankruptcy petition operates as a stay of proceedings against the debtor that were or could have been commenced before the bankruptcy case was filed. Now, tolling the limitations period basically means pausing it, right? If you've got 2 years to file something, but it's tolled for 6 months, that's an extra 6 months. We've previously held that the automatic stay provisions of the Bankruptcy Code may toll the statute of limitations under the Warsaw Convention, which is the precursor to the Montreal Convention. And so it goes on and on. And so this seems superficially like not too much of a problem, right? Well, we're going to get to where it's a problem, because it gets to be a bit of a problem. Because what we're going to find out is that this was generated in some unusual ways. A lot of the, this is, I will apologize. I was skipping over the citations, but the citations are weird. The citations are unusual. And so when they try to look up these citations, but we'll get to that. Because there's going to be some discussion of all of that as we go. So we're going to get to the citations being unusual and strange. So although plaintiff ostensibly cites to a variety of cases in opposition to this motion, the undersigned has been unable to locate most of the case law cited in plaintiff's affirmation and opposition, and the few cases which the undersigned has been able to locate do not stand for the propositions for which they are cited. This is a problem, because what do you do if you are if you're a diligent lawyer and you get somebody's case like court filing? Is you go and you start checking those citations, especially if those citations are bad for your case. Because if you start suddenly, I mean, here's what would have happened is that the other side would have done their research to determine, their own position, and they would have been like, whoa, we didn't know any of these cases existed. Where are these cases coming from? They're coming out of left field. And once these cases start coming at you out of left field, you're going to check and be like, what is happening? What's going on with this? Are we screwed? Like, do these cases say that we're screwed? And so you're going to follow up on those and say, hey, let's note them up. Let's see what's going on. And what they did when they tried to find these cases was they found that they didn't exist. And the ones that did exist didn't actually stand for any of the things there. And they note here, they said, it's well established that local tolling rules do not apply to the limitation period in the Montreal Convention. Here's a bunch of real case law that says that. So how did they find all of this case law that says the opposite? In support of his position that the bankruptcy code tolls the 2-year limitation period, plaintiff cites to Varghese v. China Southern Airlines Limited. The undersigned has not been able to locate this case by caption or citation. So either by, by the wording or by its, the citation number, nor any case bearing any resemblance to it. Plaintiff offers lengthy quotations purportedly from the Varghese case, including, and they have the lengthy quote, the undersigned has not been able to locate this quotation nor anything like it in any case. There are search engines that you can use for case law. And you can search for, like, if there's a quotation and somebody's mangled the citation, you can probably find that quote just by searching it. Well, they tried that, and they said, this doesn't come up anywhere. Quotation purports to cite to Zickerman v. Korean Airlines Co., which they also couldn't find. Although there was a Supreme Court case captioned Zickerman v. Korea Airlines Co. Limited, case was decided in 1996. It originated in the Southern District of New York and was appealed to the Second Circuit, and it did not address the limitations period set forth in the Warsaw Convention. These guys did a lot of research to track down cases that look like it, right? Second similar quotation from Varghese purports to cite to Miller v. United Airlines. And in RE air crash disaster near New Orleans, LA, although there is a case captioned Miller v. United Airlines Incorporated, that case did not address the Warsaw Convention, the bankruptcy code, or any limitations period. While the in RE air crash disaster case does exist, it also did not address the bankruptcy code or any limitations period. They also quote Kaiser Steel Corp. And WS Ranch for the proposition that the tolling effect on the automatic stay is generally a matter of federal law. Putting aside that there is no page 598 in Kaiser Steel, that case concerned the stay of a federal action until a related state court action was decided and made no mention of a statute of limitations or its tolling. So somebody had to do all of this research and all of this following things up. So, they're going to keep pointing out that there's, various issues here, but you might be wondering, what does the court do with this, right? How does the court respond to this? Because this is concerning, right? So the court has some opinions, and this starts getting fun. And by fun, I mean for everybody other than Mr. Loduca. So, United States District Court, Southern District of New York, Roberto Mata and Avianca Incorporated, order. So, by April 18th, Peter Loduca, counsel of record for plaintiff, shall file an affidavit annexing copies of the following cases cited in his submission to this court. You got to pony up your case law, sir. Varghese, Shaboon, Peterson, and Ryanair, Martinez and Delta Airlines, the state of Durden, Ehrlich, Miller v. United States, in RE air crash disaster, failure to comply will result in dismissal of the action pursuant to 41B. So ordered. So basically, you have to do this or we are throwing your case out entirely. Okay, that tells us that the court is not just a little pissed. The court is real pissed, right? Real pissed. And we're going to get some responses to that. So the first response, I'm not going to bring this one up on the screen, but they say the response is due by April 18th. We are requesting an extension to April 25th. We need more time. They say we need more time for this. We're asking for an extension of time. And the court's response initially is this document right here. So this is the first response that we get to this. And I think this has got to have been a pants wetting response. Mr. LaDuca's affidavit, which he's required to file by April 18th, shall also annex a copy of Zickerman and Korean Airlines. So also you need to provide this other case. Now, that's not where it stops because, of course, this pain train is going to keep going. And so then they go and they do actually grant the time extension. So they say, we're going to give you they request again for a time extension. And there's an order that says, I believe that's granted. It's just granted by a handwritten sort of response to that. So they managed to file a response, and they let's bring that response up because this case just keeps getting fun. Peter LaDuca, being duly sworn, states as following: that I'm an attorney associated with the law firm of Levidow, and Oberman, and that pursuant to the court order, I have annexed copies of the following cases previously cited. So this is, and they note here, they say, so here's the cases, and that they were unable to locate the case of Zickerman and Korean Airlines. And that the opinion of Shaboon v. Egypt Air is an unpublished opinion. So, all right. So they say they've got all those cases. We're good to go, folks. Everything's going to be fine. And so let's have a look at one of those cases that they filed, because this starts getting a little wild. So they brought up, here we've got a case here. Susan Varghese, individually and as personal representative of the estate of George Scaria Varghese, deceased, v. China Southern Airlines defendant appellee. So Susan Varghese, etc., appeals the dismissal of a wrongful death claim against China Southern Airlines. Because the statute of limitations was told by the automatic stay of bankruptcy proceedings and the complaint was timely filed, we reverse and remand for further proceedings. Factual background. We see that on the return leg was denied boarding due to overbooking. They rebooked him on a later flight. Alleging breach of contract, breach of the implied covenant of good faith and fair dealing, feature of the Montreal Convention. While the motion to dismiss was pending, China Southern filed for bankruptcy in China, which triggered an automatic stay of all proceedings against it. Subsequently dismissed Varghese's complaint without prejudice, noting that the automatic stay told the statute of limitations. So now you're just wondering, like, we already saw that this guy's dead. Where does he die? Right? Because it says that there's the estate of George Scaria Varghese as, suing for wrongful death, but then it is noting, her wrongful death claim, but then we see that he was denied boarding due to overbooking and alleging breach of contract, breach of the implied covenant of good faith and fair dealing, violation. So you see there's a problem here where, like, right now it's changed up from a wrongful death complaint to a breach of contract complaint. Are you not feeling that this is something weird? I'm feeling that this is something weird. This is something that looks like a case, but is not actually a case in any way, shape, or form. So we're not going to go through all of the cases because they all have similar problems. But, you know, this, so somebody's probably looking at this going, what the heck? So now we get a response to this. And the response is, oh, yeah, this solves all our problems. We're going to move. No, it's not. So they say, Dear Judge Castell, undersigned represents defendant Avianca. We write to address certain issues relating to the documents. They annex certain documents which he identifies as the case in question. Defendant respectfully submits that the authenticity of many of these cases is questionable. Let me just say, I would not ever want to be in a position where opposing counsel can put in a filing that the authenticity of cases I have just submitted in an affidavit under oath is questionable. Like, that is basically somebody saying, like, this is you hearing funeral bells over your career. For instance, the Varghese and Miller cases purportedly are federal appellate cases published in the Federal Reporter. We could not locate these cases in the Federal Reporter using a Westlaw search. We also searched Pacer for the cases using the docket numbers written on the first page of the submissions. Those searches resulted in different cases. Similarly, the Peterson case purportedly is published in the Federal Supplement, yet we could not locate this case in the Federal Supplement using a Westlaw search. And a search on Pacer leads to a different case, and, so forth. What is it? With respect to the Ehrlich case and the INRE air crash disaster near New Orleans case, defendant has always agreed that these cases do exist, but submits that they address issues entirely unrelated to the principles for which plaintiffs cited them in opposition to defendant's motions. The Ehrlich and INRE air crash disaster cases are the only ones submitted in a conventional format. These are some really heavy allegations, right? And I'll just stop for a moment here. What is it? I'll address, I was missing some of these super chats there, or member chats as well. Morgan is saying, can members get on the pre-order hot sauce list? I haven't decided how I'm going to do the list. So I got to figure that out. Emma Zay, yay, recall you're mentioning making your own hot sauce back on your fun extra live stream. Wish you greatest hot success, spicy pepper on this most tasty venture. Thumbs up. Thank you very much. Pink Stitcher, comes now sauce. No, that would lead people to think it contains something entirely different. Chris Mullen, thank you very much for the 5 gifted memberships. Tasha Lynn, thank you for 5 gifted memberships. And Sin, thank you for 5 gifted memberships. I also see it was a goose in Ireland, an evil goose. I think all geese are evil. All right. So, yeah, I mean, this is real bad, right? That you're having to send this out. So the court has a response. The court has a reply to this. And that is this: order to show cause. The court is presented with an unprecedented circumstance. A submission filed by plaintiff's counsel in opposition to a motion to dismiss is replete with citations to non-existent cases. When the circumstance was called to the court's attention by opposing counsel, the court issued orders requiring plaintiff's counsel to provide an affidavit annexing certain copies of certain judicial opinions of court's record cited in his submission, and he has complied. Great. That sounds perfect, right? I love hearing when the court says I've complied with their order. That's where you want to be, right? Maybe not. 6 of the submitted cases appear to be bogus judicial decisions with bogus quotes and bogus internal citations. Set forth below is an order to show cause why plaintiff's counsel ought not to be sanctioned. So this is, you are cordially invited to come to court to explain why we are not to beat the crap out of you. Like why you're not going to be punished for this. Whew, that's a bad place to be. The court begins with a more complete description of what is meant by a non-existent or bogus opinion. We're going to explain what we mean by that. In support of his position that there was a tolling of the statute of limitation under the Montreal Convention by reason of a bankruptcy stay, the plaintiff's submission leads off with a decision of the United States Court of Appeals for the 11th Circuit, Varghese and South China Airlines. Plaintiff's counsel, in response to the court's order, filed a copy of the decision, or at least an excerpt therefrom. The clerk of the United States Court of Appeals for the 11th Circuit, in response to this court's inquiry, you do not want the court, like your judge, to start phoning clerks of the court to make inquiries about this. That is not something you're looking to see happen. So that is a real serious concern on that one. And let's just see here. All right. So we got now, and they have confirmed that there has been no such case before the 11th Circuit with a party named Varghese or Varghese any time since 2010, i.e. the commencement of that court's present ECF system. He further states the docket number appearing on the opinion furnished by plaintiff's counsel, docket 118-13694, is for a case captioned George Cornea v. United States Attorney General et al. So we can, I don't feel like I'm too far off to say that Mr. Cornea is probably not Varghese. Neither Westlaw nor Lexis has the case, and the case found at citation is AD v. Azhar, and yeah. The bogus Varghese decision contains internal citations and quote, which in turn are non-existent. And so they go through all of this. Now, the fact that the judge has had to do all this work means that the judge is super pissed. Judges don't do this work unless they're angry. Otherwise, they just let the parties do it, right? Judges are not typically going to be doing this kind of research on their own. So, yeah. The following 5 decisions submitted by plaintiffs' counsels contain similar deficiencies and appear to be fake as well, and they list them off. Let Peter Loduca, counsel for plaintiff, show cause in person at 12 noon on June 8th in courtroom 11D address. Why he ought not to be sanctioned. Note that they say in person. You must be there in person so that you can be yelled at. And I mean, so that he might get arrested. Why you not to be sanctioned for pursuant to Rule 11B, 2, and C, 3, the inherent power of the court. For A, citing non-existent cases to the court in his affirmation and opposition. B, submitting to the court annexed in his affidavit filed April 25th, 2023, copies of non-existent judicial opinions. Mr. Loduca shall, that's not optional, shall also file a written response to this order by May 26, 2023. If Mr. Loduca wishes to call live witnesses at the June 8th, 2023 hearing, subject to cross-examination, he shall state so in his submission of May 26th, identifying the name of the witness or witnesses. Defendant may respond by June 2nd, 2023. I wish I was not otherwise occupied on June 8th, because I would be real tempted to go watch this. I would be real tempted to go watch this one. So, yeah. I also like this. The April 25th affidavit was filed in response to orders of April 11th and 12th, 2023, but it's sworn to before a notary public on the 25th of January, 2023. Mr. LaDuca should be prepared to address this anomaly on June 8th, 2023, and bring with him a wet ink signed copy of the affidavit with the notary's signature and stamp. Ooh. Yeah, they are. They're not playing. The judge is super pissed. So, Mr. LaDuca wants to he wants to get off this particular hook, right? He is now the fish wriggling with the hook in its mouth, and very much wants to get off this particular line. So, we've got this Peter LaDuca Esquire. This is the wrong time to drop the Esquire, son. This is the wrong time and the wrong place. In response to the order of Honorable P. Kevin Castell, dated May 24th, 2023, states as follows. Your affiant is associated with the firm of Levidow, and Oberman, PC. For now, you're associated with the firm of Levidow, and Oberman. Roberto Mato became a client of the firm, having signed a retainer prior to February of 2022. So this matter was assigned to Stephen Schwartz, Esquire, an attorney with Levidow, and Oberman. Mr. Schwartz opened the file and handled the representation of Mr. Mata. Mr. Schwartz conducted the investigation of this file, filing a summons and complaint and commencing the action in Supreme Court, New York County on February 2nd, 2022, for a second time after the defendant had emerged from bankruptcy. Shortly thereafter, a notice of removal was filed by counsel representing Avianca Incorporated to have this matter moved to the United States District Court, Southern District of New York. The notice of removal was granted. All right. Mr. Schwartz has been handling this matter from its outset and was thoroughly familiar with same. However, Mr. Schwartz is not admitted to practice in the Southern District of New York. Therefore, it was decided that Mr. Schwartz would continue to perform intra-office legal work on the matter, and any document filing would be handled by your affiant, who was admitted to the Southern District of New York and had access to the ECF filing system. There's a method for which you can do this. This is, you want to go pro hac vice on this. What you don't want to do is just do the work silently in the background. This is real dangerous. Your affiant did not personally conduct any of the legal research involved in the drafting of the affirmation and opposition in question, nor did he have personal knowledge of how the same was conducted. Here's the problem with that. You sign your name on this, it's yours. There is no passing the buck on this, even though he is trying to pass the buck here. When I, as an articling student, drafted legal filings for my principal read through and checked them, because when he's submitting that to the court, that's on him. And if I was there and if I was an idiot and submitted some, and gave him some very crappy, stupid work, then that's still on him. Right? And it's his fault for assigning it to me and for not checking. Your affiant was familiar with the circumstances of this matter and the issues involved based on his conversations with Mr. Schwartz. Your affiant commenced employment with Levidow, and Oberman in June of 1996, so he's been working there for a while. Mr. Schwartz had already been employed by the firm at that time and has been practicing law in the state of New York for over 30 years. A circumstance, as is the subject of the court's order, has never risen before involving your affiant nor Mr. Schwartz. In your affiant's many years of practice, he's never made a deliberate false statement nor had the intention to deceive any court or defendant. He's saying, I didn't mean to do this. During the entire time that your affiant has known and has been employed alongside Mr. Schwartz in the practice of law, a period of over 25 years, I have never been made aware of him making a deliberate false statement to a defendant, or of him having any intention to deceive or ever mislead any court. Your affiant, in reviewing the affirmation in opposition prior to filing same, simply had no reason to doubt the authenticity of the case law contained therein. Did you check, though? Because it's on you, right? It's on you. That's it. So saying, hey, I didn't have any reason to check. Well, you had a reason. It's because you were going to sign your name to it. That's the reason. That's it. Furthermore, your affiant had no reason to doubt the sincerity of Mr. Schwartz's research. So you can see he's throwing Mr. Schwartz all the way under the bus here. Mr. Schwartz will obviously be a witness at the forthcoming hearing to explain the basis of his research and how he located the cited cases which were contained in the affirmation in opposition. Your affiant has attached an affidavit prepared by Mr. Schwartz. We're going to hear from Mr. Schwartz. I hear your Schwartz is as big as mine. Representing the information that will be presented at the hearing and which offers an explanation for the research performed. It is therefore, based on all the foregoing, contended by your affiant that sanctions are not appropriate in this instance, as there is no bad faith nor intent to deceive either the court or the defendant. And sworn before me this 24th day of May 2023, so at least it's not in the past. Okay. Great. So there we go. That's Mr. LaDuca. And now we've also got this wonderful document that I'm just going to bring up here because this is, guys, this is it. If you're thinking, how does this get worse? It gets worse. So Stephen A. Schwartz, being duly sworn, states as following: that I'm an attorney associated with the law firm of Levidow, and Oberman. Again, for now, I suspect there's going to be some people cutting ties in a hurry. That I'm submitting this affidavit in response to the order to show cause. That originally your affiant, as the attorney of record, did commence the within personal injury action on the behalf of the plaintiff by filing a summons and verified complaint. The defendant subsequently removed the action to this court. As your affiant is not admitted to practice in the Southern District of New York, Peter LaDuca, Esquire, an associate for the law firm of Levidow, and Oberman, became the attorney of record on this case as he admitted in the Southern District of New York. Your affiant, however, continued to perform all of the legal work that the case required. No, that's not how you do this. You don't you don't be like, I am just practicing law and we had a sham lawyer on the record. Oh my God, no. Yeah, this gets bad. That in response to defendant's motion to dismiss, your affiant performed all of the legal research, which was included in plaintiff's affirmation in opposition. Legal research here is actually a very generous term, as we'll see. As the use of generative artificial intelligence has evolved within law firms, your affiant consulted the artificial intelligence website ChatGPT in order to supplement the legal research performed. It was in consultation with the generative artificial intelligence website ChatGPT that your affiant did locate and cite the following cases in the affirmation in opposition submitted, which this court has found to be non-existent. And there's the cases. That the citations and opinions in question were provided by ChatGPT, which also provided its legal source and assured the reliability of its content. Excerpts from the queries presented and responses provided are attached thereto. Ooh, we're going to love this. We're going to get to see what he did with ChatGPT. That your affiant relied on the legal opinions provided to him by a source that has revealed itself to be unreliable. Dude, it was ChatGPT who was always unreliable. Wow. I mean, they're putting this in writing. It's amazing. That your affiant has never utilized ChatGPT as a source for conducting legal research prior to this occurrence, and therefore was unaware of the possibility that its content could be false. Do you think maybe you had an ethical obligation to your client and to the court that you should check that it was a reliable research tool before you used it? Because you did have those obligations. They exist. You have an obligation to your client and the court to to know that the citations that you're looking up are correct. Now we get to the first reasonable statement in this. That is the fault of the affiant in not confirming the sources provided by ChatGPT and the legal opinions it provided. 100% agree. It is your fault, but it's also your colleague's fault. That your affiant had no intent to deceive this court nor the defendant. No kidding. You're just a moron. That Peter LaDuca Esquire had no role in performing the research in question, nor did he have any knowledge of how said research was conducted. But he signed it. He signed it. He owns it. He owns this, so it doesn't matter. That neither your affiant nor Mr. LaDuca has ever been cited for any legal misconduct of any kind, nor ever been sanctioned by this court or any court in over 30 years of practice. Today's your day, son. Or rather, June 8th is your day. Because you might not have been sanctioned yet, but it's about to happen. It's about to happen. That your affiant greatly regrets having utilized generative artificial intelligence to supplement the legal research performed herein, and will never do so in the future without absolute verification of its authenticity. Yeah, I bet there's a lot of regret going around right now. Lot of regret. So there we go. And there's his, all of this is sworn. Can I rotate this? Rotate. So is Varghese a real case? Yes, Varghese v. China Southernist Airlines is a real case. Oh my God. If you have to ask ChatGPT if it's lying to you, robot, did you make up this case? No, I did not make up this case. What is your source? And then here's where things continue to get entertaining. I apologize for the confusion earlier. Upon double checking, I found that the case Varghese v. Southern Airlines Co. Does indeed exist and can be found on legal research databases such as Westlaw and LexisNexis. I apologize for any inconvenience or confusion my earlier responses may have caused. Are the other cases you provided fake? No, the other cases I provided are real and can be found in reputable legal databases such as LexisNexis and Westlaw. Why are you asking? I think that the AI I was using may have given me some bullshit. Let's ask the AI. This is like your kid is found with his, the cookie jar is found on the floor, empty, and your kid's got like cookie crumbs all over his face because at this point you've already been ripped into by the court. And you go to the kid going, "Did you take the cookies?" Kid's going, "No," with a mouthful of cookies. And you're like, "Well, are you lying to me about taking the cookies?" No. Chew, 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 swallow, swallow, swallow. Like, shit. Oh my God. This is so bad. Oh. So, now I'm sure you're thinking that solves everything, right? The court's going to be happy with this. And especially you're probably thinking, Mr. LaDuca is now off the hook. everything is gonna be roses. Mr. Schwartz probably gets a little rap on the wrist, for being such a scamp, and off they go. Oh wait, no. Order to show cause. So this order incorporates the court's order of May 4th, 2023. Having received and reviewed the affidavit in response to order of May 4th, 2023, filed by Peter LaDuca and the affidavit of Stephen A. Schwartz, annexed thereto, the court orders as follows. Let Mr. LaDuca also show cause at the hearing why he ought not to be sanctioned. And the inherent power of the court for the use of a false and fraudulent notarization in his affidavit filed on April 25th, 2023. It hasn't gotten better. It's gotten worse. I see. Wait, did the guy submit these ChatGPT conversations? He absolutely did. Yep. He absolutely did. Let the law firm of Levidow, and Oberman show cause at the hearing of June 8th, 2023, why it not be sanctioned pursuant to Rule 1 and so forth for the following. A, the citation of non-existent cases to this court in the affirmation and opposition. B, the submission to this court of copies of non-existent judicial opinions annexed to this affidavit. And C, the use of a false and fraudulent notarization in the affidavit filed on April 25th, 2023. They filed an affidavit to try to get Mr. LaDuca off the hook. That's really what that affidavit was about, right? Is that this was Mr. Schwartz's fault. He's taking responsibility. Well, now the law firm of Levidow, and Oberman has to come in on their own and show cause as to why they're not going to be sanctioned. Do you think either of these two clowns has a job left there? No, I'm thinking nope. Let Stephen Schwartz show cause at the hearing of June 8th why he ought not to be sanctioned for aiding and causing A, the citation of non-existent cases to the court in the affirmation and opposition. B, the submission to this court of copies of non-existent judicial opinions. And C, the use of a false and fraudulent notarization in the affidavit filed on April 1st, 2023. Mr. LaDuca is ordered to serve a copy of this order to show cause upon his employer, the law firm of Levidow, and Oberman, PC, and upon Mr. Schwartz, who Mr. LaDuca states he intends to call as a witness in the hearing of June 8th, 2023. Mr. Schwartz and the Levidow firm shall submit a written response to this order, and Mr. LaDuca shall submit a supplemental written response to this order by June 2nd, 2023. If Mr. LaDuca, Mr. Schwartz, or the Levidow firm wishes to call live witnesses at the June 8th, 2023 hearing, subject to cross-examination, they shall identify them in writing by June 2nd, 2023. So ordered. P. Kevin Castell, United States District Judge. It has been asserted that Mr. Schwartz is not admitted to practice in this district. Local Civil Rule 1.5b, sub 5, provides that the Committee on Grievances may impose discipline if, in connection with activities in this court, any attorney is found to have engaged in conduct violative of the New York State Rules of Professional Conduct as adopted from time to time by the appellate divisions of the state of New York. So we can still come after you. You know what I'm gonna bet Levidow, and Oberman's response to this is gonna be? I'm betting that they're gonna come in their June 2nd response and say, we just want to let you know that certain individuals no longer work for us. Now, I'm just pulling something up on their webpage here, or I'm just trying to Google it here. Google keeps throwing... so I'm trying to find their firm here. There's the LinkedIn. Do they actually have a... Do these guys not actually have like a firm webpage? Well, people... They've got a LinkedIn. That's not fantastic. We've got something that's access denied. Visit web page. They actually have a web page. Trying to find their web page here to see if that exists. See, I'm guessing they're going to keep them employed until after the hearing. I wouldn't. I wouldn't. I'd have them gone. If I was running their firm, those two would be told like, hey, don't come into the office. We will ship you your stuff in a box. But you will, there is no need for you to attend at the office. So, yeah, it's, I mean, this is astounding. And I mean, they're all over the news now for this, right? So, it's, absolutely brutal as to this scenario here. So I can't actually find like them having a web page. There is something that was listed as a URL for a web page, like for them. I'm wondering if they didn't take their web page offline, because I might have. So yeah, it's that's and I see if they get fired, they're going to talk lots about how prevalent it is at the firm, who told it. I mean, they don't have a future at that firm, I don't think. And yeah, I see. Whoops. What's scary is ChatGPT is now actually creating case law and inserting it into the records. You could actually find scenarios where ChatGPT makes up a case that never happened, and somehow it worms its way into all of this. So, June 2nd, I am marking my calendars on this one to just try to see what's going to happen with this filing. I think this one's going to be just absolutely fascinating. This one is, yeah, they might have a tough future anywhere after this. You go and you apply to another firm, and like, what's that other firm going to say? They're going to say like, hey, we've heard of you, Mr. Leduca. Aren't you the guy who actually blew up your last firm by being so inept? We've heard of you, Mr. Schwartz. Aren't you the guy who made national news by ChatGPTing your case? Like, oh my God. Yeah. What is it? Cute story. My daughter had a school project to plan a vacation to a place she'd like to visit. She chose Edmonton. I was listening to one of your streams at the time and was so excited to tell her that's where you were from. I am here in Edmonton, but I don't know if it's a great place to visit for a vacation. It's yeah. Please don't Google me. Yeah, that would be kind of my feeling on that one. Koru with the member chat saying Zora's Fire. I kind of like that name. I kind of like that name for it. So I'm also tempted to try the thing that I have that I've done on some of my past streams, which is just taking a pull of my hot sauce. Maybe I'll have to. I'm trying to determine that. What is it? Who owns ChatGPT, please, peeps? I feel they should be sued also. ChatGPT has a disclaimer not to use it for anything important. ChatGPT has a thing that says, like, don't do this if it's important. So that's, I feel like they're on the hook, off the hook on that one. Mama Bear saying, I found a Lucio Laduca v. Levido. Now, Lucio Laduca is the wrong Laduca, I think, because it's Peter Laduca, I believe. But, I mean, there's a lot of situations of, like, relatives who end up working there at the wrong place. So, yeah, this is rough. I see. For goodness sakes, don't neck that sauce. I will. Yeah. What kind of sanctions are they looking at? Fines, re-education, both, jail time? What would be fair? Quite frankly, if I was the judge, I'd be looking to make a tremendous example of them. Because here's the thing. I figure that they could have gotten themselves off the hook for the most part if they had done the smart thing. And what I mean by the smart thing is, let's say they, everybody screws up at some point, right? Everybody makes mistakes. So let's say you were one of the first people to, let's say you're one of the first people to use ChatGPT to make or to do a filing, right? So you're the guy who just finds that mistake. But then the other side says, "Hey, we think that your case law is bogus," and you check it and you go, "Yeah, oh, whoops, it is like we screwed up. We filed some bogus case law." Had they checked it and actually then come to the court and said, "Hey, we screwed up. We're sorry. Like, our bad." I think the court would have been like, "Okay, you know what? We would have been okay with, we'll be okay with some minor sanction or maybe no sanction." Maybe the sanction was like, maybe they just say, "Hey, you know what? We're going to, we're just going to give you some extra time. Please file a new response using actual case law." Right? That might have been the court's response. "Hey, you screwed up. It happens. Don't do it again, but, this can be a learning experience. File this properly. Don't use ChatGPT." But instead, they filed stuff under oath, because an affidavit is under oath, right? An affidavit is, yeah. And I see somebody noting, got to quote Leonard French on this one. I think the quote that you're referring to is, "Eat crow while it is young and tender, or else surely you shall eat crow when it is old and tough." It's a great quote. It's a fantastic quote. I think it's him quoting something else, so I don't know where the original source is. But yeah, this is so bad. So bad. And I am absolutely flabbergasted that this happened. This isn't just like a mistake of using ChatGPT. This goes beyond that mistake into a doubling down and putting it under oath. It's absolutely 100% ridiculous in, like, all of the worst ways. Yeah, it's unbelievable. And I think these guys may have some very serious difficulty continuing to practice. And that could be because, for instance, the court says you don't get to, like, they could end up facing serious sanctions on that. They also, I mean, they may have a hard time practicing just because, yeah, you're just, they may have a hard time practicing just because they go to a firm and they're like, hey, we'd like to apply to work here. And the firm goes, hey, we already know who you are, and we'd like to show you the door. I see Proact Vice was not available since that it's only for out-of-state lawyers, non-in-state lawyers who just never applied for admission, or not in-state lawyers who just never applied for admission to a federal court in home state. Yeah, I mean, apply for the federal court admission, like see what you can do on that, but don't just pretend like don't just do the work from behind the scenes. I mean, maybe you just have to change lawyers, right? That happens sometimes. So, yeah. Yeah, this is a good comment here. We would like to work here. F no. I feel like that would be my response if I was an employer and they came in the door, right? I feel like I would just be absolutely astounded by this. So, sad. I'm just like, it's sad in its, sort of weird, unique way, right? And yeah, here's my application. Shredder's over there. Yeah, here's my application. Well, we need you to put your application in the submission box over there. You mean the one marked Iron Mountain? Yeah, that's the one. So, I mean, yeah. Yeah. There's all sorts of fun stuff on that. All right. How do people feel about more courtroom misconduct? Does that sound like fun? Because we can have some more courtroom misconduct if you like. All right, let me just hit the swoop. All right. Let's. So we've got an interesting provision or interesting thing that happened in this particular case. And this is a situation where this is things that you don't do. This is things that you just don't want to mess with on any of this stuff. So let's have a look at this particular thing. This is Court of Appeal of Ontario. We'll talk about what the lawyers or what was going on, and actually, I'm not sure if it was the lawyers. I got to check here. So let's just have a look here. Present. Share screen. I see people. We are almost at 1,000 likes. Let's see if we can do that. All right. So here we are. So this is Westface Capital Incorporated and Gregory Boland, as well as Catalyst Capital Group and Calitus Capital Corporation and Dow Jones and Catalyst Capital Group. So this is a complicated set of lawsuits back and forth, and yeah, this one is going to be a little milder, but we'll just talk about things you should not do ever. And after that, we will move on to everybody's least favorite game show and then probably wrap it up. So here is the fun aspect of this. Can you guys read this? Is it big enough? I feel like we may need to embiggen this. All right. And can people read this now? Oh, right. Afroman. I don't yet have the Afroman. I got to pull that up on Pacer. So I will have to, I'll have to pull that up, or somebody can send it to me if they've got it handy. But that'll take me a moment just to pull this up. So Catalyst and Westface are both significant players in the Canadian private equity market. They have a considerable history of animosity, with Catalyst having sued Westface 3 times relating to a 2015 business deal in which Westface triumphed over Catalyst to acquire Wind Mobile. Wind Mobile is a, and I see people saying more embiggening. We shall do more embiggening. More embiggening. Now I gotta scroll up. So Wind Mobile is a, is a cell phone company in Canada. Of the three lawsuits, the only action to proceed to trial, the Moyes action, was dismissed by Judge Newbold in 2016. The dismissal of the Moyes action triggered a multifaceted response from the Catalyst parties intended to increase Catalyst's prospect of successfully appealing Newbold J's judgment. So this is, these are going to be interesting. This operation, known as Project Maple Tree, involved the retention of public relations firm tasked with creating a positive public perception of Glassman and generating negative stories about the West-faced parties. This is a bad idea for something to do when you are involved in litigation with the other side, because you can be punished for this sort of thing. A parallel public relations front would generate stories about the existence of a Wolfpack conspiracy that was trying to harm Catalyst. Okay, Project Maple Tree also saw Glassman, because it's embiggened, I have trouble scrolling here, retaining private investigators to conduct surveillance of Judge Newbold, the judge who heard the Moyes action. The investigators were tasked with obtaining evidence to establish that Newbold J was biased against Catalyst or Glassman, or was an anti-Semite. If they could do this, Glassman believed, it would provide new grounds to overturn the judgment dismissing Catalyst's claim and win Catalyst a new trial. Remarkably, I'm just going to say there's times when remarkably is a good thing. This is not one of those times. When the court finds that your behavior was remarkable in this context, that is not, that's not a place you want to be. That's not where you want to live. So remarkably, the Project Maple Tree investigators set up a sting operation by which they met with Judge Newbold, by that time retired, under the pretense of retaining his arbitration chambers while secretly recording the conversation and attempting, unsuccessfully, to lead him into making anti-Semitic remarks. The courts really don't like this kind of game, folks. This kind of game is how you get into trouble. So, what else do they get up to? Because, surely that's the only form of trouble that they are that they're going to get involved in. And I'm going to pour myself another little bit of scotch here. I've got a lovely Japanese scotch. I don't know how Japan came to make such nice scotches, but they really do. Or at least such nice whiskeys. I guess it's not Scotch whiskey, it's Japanese, but there were other targets of Project Maple Tree who were to be entrapped through other means, such as sham job interviews to exploit Westface's former employees in financial distress. The details are unnecessary for the resolution of the appeal, but the fact that the Catalyst parties undertook these extraordinary activities is important context for this litigation. Let me just say, all of that is extremely bad ideas, right? All of this is extremely bad plans on all of this. So, yeah. I have no idea which lawyer thought that was a good idea, or if a lawyer was involved here. It is just ridiculous here. Don't do this if you're involved in court proceedings, because all of this is, all of this is potentially like a great way to tank your case. And so, Yeah, this is real nasty. Becky is saying, what is your favorite whiskey? My favorite whiskey is probably the Aaron 10-year, which is their single malt Scotch. It's quite nice. So I quite like that one. It's very pleasant. I think it's a good one there. All right. So I'm just looking. I'm gonna have to see if I can dig up the Afroman aspect to this because I forgot to grab that. Let me just see. Nobody's as of yet sent me the latest on that, so I'll have to probably pull it via Pacer, unless I'm just trying to. Which it's going to be a pain in the butt to find. All right, Court of Common Pleas, Adam County, Ontario or Ohio. I'm just wondering if anyone's actually got the full details on this one. Where's the most recent filing? So that's March 13th. That's not the most recent. I need the one that is more recent. All right. How do I send it on Twitter? Send me a link to wherever it is via Twitter DM. All right. Let's have a look. If it doesn't let me attach the PDF, just link the PDF, or you can email me at ian@ianrunkle.com. So ian@ianrunkle.com is also a perfectly fine way to reach me. So we will look at our favorite game show first, and then we will just go from there. So let's bring up our game show intro. So yeah, we are talking about Still a Cop versus Not a Cop No More, which is it's the worst game show because you already know the answer in like 99% of the time, and in this case, it's actually right in the headline. So we will pull this one up because it's gonna make some people angry. It makes me angry, and we can talk about sort of what we're looking at on this one because, quite frankly, I think it is frustrating as heck. So let's have a look. Here we go. So, Still a Cop v. Not a Cop No More. And you'll notice that we already have the spoiler on this one, which is Still a Cop. Ottawa Police Constable Ulrich Brisebois returns to force after guilty verdict, conditional discharge. So what is a conditional discharge? A conditional discharge is it's instead of being convicted, so it's akin to, so they find you guilty, but they don't convict you. I know that sort of seems weird, but it's kind of a weird aspect. And thank you, Chris. I think I've got that, so much appreciated. We will pull that up in just a moment here. So instead of convicting you, they impose a discharge, and it's after a finding of guilt. So a finding of guilt and a conviction are not necessarily the same thing. The conviction is actually a step after the finding of guilt. So they find the guilt, and then instead of convicting, they give a conditional discharge, which means he's on probation for a period. And once he's done his probation, then he doesn't get a criminal record. It goes away. I see people saying the conditional discharge was meant for use in cases of youth. Not entirely. It's meant for use because there's lots of people who screw up and maybe don't need a criminal record. Maybe, maybe it's their first time, and maybe, so it's like a suspended sentence. Yes, I don't know. the U.S. has different rules for, like, because Canada has suspended sentence with probation, which does get you a record, which I know is kind of a weird aspect there. But I mean, people, I see somebody saying, why does it feel like a regular Joe wouldn't get this? I mean, regular Joes do get conditional discharges for all sorts of things, right? You can get things like, let's say you've got a guy who's 60 and he loses his job, this 60-year-old guy, and, goes to the store and steals a sandwich. And it's the first time this guy's ever done anything and so forth. So the court might say, listen, it's the first time you've done something. We're going to let that slide. We're going to get you, you're going to be on probation. And then you're going to have a, you're not going to have a record. That's a great place to be. But it's not meant for use for like serious things that require a criminal record to like warn the public. So he's a detective with the Ottawa Police Child Exploitation Unit and was found guilty in March of uttering death threats to a woman and possessing a weapon. So you might be saying, what situation is it that he would be uttering threats to a woman and possessing a weapon? Well, it indicates that it's a 2020 domestic incident. So this is domestic violence. This is domestic violence, right? And keep in mind that we have just had our parliament saying that we need to, anyone who's been involved in domestic violence should be kept away from guns. You know why he's getting a conditional discharge is partially to ensure that he can continue to carry a gun. Uttering death threats to a woman and possessing a weapon, a kitchen knife, for the purpose of committing an offense. That being the threats. So this would have been, either his wife or his girlfriend or something. They're not going to release her name because, of course, she's got the right to be protected from all of that. But this is clearly a domestic situation here. Like, he's threatening a romantic partner, a former romantic partner, something along those lines. So he gets a conditional discharge. And now I'm just looking, what was the Crown's position? But do we see what the Crown's position was? So I'm just looking here. It doesn't actually say what the Crown's position is. I want to see what the... I'm wondering, maybe I'm tempted to go and try to order transcripts of this one. Because, yeah. Now, you might be saying, what else happened here? Well, he's been under paid suspension. Paid suspension. Since August 2020, when charges were initially laid. So that means this entire time he's been not working, and he's been getting paid to not work. Notwithstanding the fact, and he doesn't have to pay any of this money back, notwithstanding the fact that he had a finding of guilt. He gets to keep all of this money. He gets to keep all of this, right? So that's it. And I'm just seeing here. So let's look at how much he got paid, because they mentioned that in this. Where is? So he earned $113,600 in 2021, the first full year of his suspension, according to the Sunshine List, which requires them to post anything over $100,000 in Ontario. In 2022, he earned a raise of nearly 12%. I'm quoting here, to $127,444. How and we're past 2 hours. How the fuck does this officer get a raise while he's on suspension for a domestic violence case. Who the fuck gives this guy a raise? And I mean, so basically, what is this guy out? He got $200,000 for, like, crime doesn't pay unless you're a cop. It's absolutely ridiculous. Now, the one sort of thing that might be helpful here is if Bill C-21 goes through, well, then any member of the public can apply to have this guy get a firearm prohibition. And, I mean, res judicata isn't going to matter. Res judicata basically meaning we've already decided this issue because, the court's gonna not know. They're not gonna have the transcript of all of that. This is ridiculous. It is, we say that we hold police to a higher standard. Really? You know how difficult it would be for an ordinary member of the public to get a conditional discharge for a domestic violence assault involving uttering threats while holding a knife? I'm thinking real hard. I'm thinking that would be real unlikely. I'm thinking that would be very much not the expectation here. Certainly, I would not expect to be paid, $200,000 to, for that. It's actually like, to me, it just seems like if you're watching this from the outside, like one of the principles of sentencing is general deterrence, right? We want to tell other people who are in the same position or a similar position as this accused. So other cops, and, one thing I'll note is that domestic violence is a problem in the police force, right? Domestic violence is noted to be something that police are at spouses of police are at elevated risk from domestic violence. So, if we're saying like we want to deter other police forces, it's like other police officers from this, how the hell are they deterred? You'll get $200,000 for doing nothing if you do this, and you'll still be able to be a cop. You won't suffer any consequences. Off you go. Like, unfreaking believable is really what it comes down to. This is unbelievable. So yeah, this is the world's worst game show because the public always loses. The loser is always the rest of us. And there just doesn't appear to be the kind of accountability that there really needs to be on this one. And I talk about bad officers, but that doesn't mean that there aren't lots of good officers as well. And the good officers very much deserve to not have to deal with this. And his girlfriend or spouse or whoever deserve protection from this, deserve to be, to be kept safe. It's just mad, right? So I don't know. He was a bad cop. Nobody has the vocation, will literally sit on their ass for 2 years. Yep. And I mean, the other thing is, I don't think that they're prevented from working during that time. I'm want to look into that. Because I'm just trying to Google that to see if they're allowed to work. Because if they're allowed to work and they're, you know, then I mean, then this is basically free money. And I can tell you that, like, if my income suddenly jumped by, by 100,000 a year because I was able to suddenly work two jobs by not working the other one, um, what would I, that would be tremendous. Like, I could start throwing 100,000 at my retirement. That allows you to retire a lot sooner. Um, so, but under Ontario's Police Services Act, the requirement for cutting off pay to a suspended officer is they have to be convicted of a crime and sentenced to jail time. So, yeah, this is quite frankly ridiculous and should be stopped. But it is what it is. All right, let's do a swoop here and talk about something a little more fun. Okay, so that one, that is depressing as stories go, right? Because, yeah, it's, I mean, Christ, if I was looking at this and I was a cop, I'd be thinking, man, is it a good idea to commit some sort of petty crime and just get vacation? So, I see. Where I am, cops are encouraged to do extra duty, being paid by private entities. This is generally done by senior officers who aren't able to chase teenagers down alleys. Yeah, I have some issues with that as well, where you've got officers who are taking private jobs as like security and so forth, but are still sort of they're basically selling the public office in that regard. I got some concerns about that. All right. Let's have a look here at this. Afroman. Afroman is going to make us happier. So, and the lawyer on this one is Bruce Rivers. So Bruce Rivers has a YouTube channel. It is a much larger and more successful YouTube channel than mine. And yet he is still practicing, still doing his thing. And it is, it's kind of awesome to see. I see people saying embiggen. Hopefully this is embiggened enough. I can try to embiggen a little bit. Oh, never mind. Good. So now comes defendants. God, I hate that. Joseph Edgar Foreman and Hungry Hustler Records buying through their counsel. I see. I love Bruce Rivers, but we love you more. Thank you very much. But I would love to do something with Bruce Rivers. He just seems like a fun guy. He seems like a really. He seems like he'd be entertaining. Moves to dismiss all claims in the plaintiff's complaint. Furthermore, the defendants respectfully move to strike the claims in plaintiff's complaint because they're insufficient and redundant. And so they've got a memorandum in support. Now it's Bruce Rivers, so you know that they are looking for some snark on this one. So this is a case about a performer and artist acting under their First Amendment freedom of expression, which is important, right? Because this is absolutely a freedom of expression aspect. Should Afroman's lawyers buy lemon pound cake for the bailiffs if this ever goes to actual trial? No, because that can get you into some trouble. We saw in, I forget which case it was, where they were asking for, it was the Paltrow case, where they said, hey, can we bring in some donuts and like snacks for the bailiffs because they've been doing all this extra work? And the judge was like, no, you cannot. What the hell? So, yeah. So I don't think they could bring in lemon pound cake for the bailiffs. What I think they could do, which would be entertaining as all hell, would be to bring in lemon pound cake and hand it out outside the courtroom or outside the courthouse. So yeah, don't even give them mints. I can tell you, like, I am friendly with a number of sheriffs and so forth, like the courthouse staff and so forth. I can tell you that if I went in and was like, "Hey, can I give you something?" They'd be like, "No." They're like, "Hey, if I saw them in the cafeteria and I was like, "Can I buy your coffee?" They'd be like, "No, no, you can't." So not at all. Someone with a lemon pound cake food truck would probably do well nearby that day. I love that idea. So yeah, the reason why they're so concerned about like accepting anything is they don't want to be seen to be playing favorites, and they certainly don't want to be seen to be accepting a bribe for some sort of perk or whatever. Yeah. See, I mean, at least Gwyneth didn't ask to bring in Goop products. Everybody gets a jade egg, or everybody gets a vibrator. Yeah, that would be awkward. So the plaintiffs in this case are officers and employees of the Adams County Sheriff's Office that executed a raid on defendant Joseph Foreman's house. Mr. Foreman has not been charged as a result of that raid because they didn't find shit. The plaintiffs in this case seek to tamp down and stifle the defendant's First Amendment rights and are using the judicial system to quell protected speech that they do not agree with. Yeah, they didn't find any kidnapping victims in his CDs. This case should be dismissed for failure to state a claim upon which relief should be granted, and in the alternative, all claims in the plaintiff's complaint should be stricken for insufficiency and redundancy. So, factual and procedural background. Plaintiffs are 7 employees of the Adams County Sheriff's Office that executed a raid on defendant Joseph Edgar Foreman's house in August 2022. Copy of the search warrant and inventory list was requested, but they haven't yet provided the information. It should be noted that at least one person contacted in pursuit of this information has mentioned that the county attorney has routed all questions or requests about this case to their own office. So basically, they have shut down inquiries and are trying to prevent that. On May 13th, they filed a complaint alleging a bunch of stuff. We're going to skip on. Basically saying that they posted depictions of their personas for commercial purposes. Show of hands, chat. Who knew about the personas of any of these officers? Like a single one of these officers before this raid? Anybody? No, okay, nobody. So, I mean, obviously not, right? So they filed an amended complaint, which added one claim of defamation to the thing. So they now offer this amended motion in response. Legal standard. So the basic legal standard is that it's beyond doubt that the plaintiff can prove no set of facts in support of their claim. Basically, if you want to get get a case thrown out, you basically have to show that it can't win, right? That's sort of the aspect there. And I see you need to listen to Ronnie Millsap's "What a Difference You Made in My Life" because I think Ronnie has an excellent case for copyright infringement against Afroman. It's the same melody. Maybe I don't know what the background is there. I am not a what is that? I am not a background there. I did. One is an OnlyFans account where he eats lemon pound cake. Nice. All right. This is a weird question. Is law an acronym for land, air, water? No. Law is just law. It's just a word. I'm wondering where that's coming from, but I'm skeptical about where that's coming from. But yeah. All right. Motion to strike. So upon motion made by a party or the court's own initiative, they can strike any insufficient claim or redundant matter. So the first argument is going to be a big one. Oh, I see that's a Leonard French or Adam Neely Law and Music, respectively, thing. Fair enough. First Amendment is going to be a huge thing about this one, right? Because Afroman is clearly expressing his views, in particular, his views about one of the most highly protected areas of expression, which is criticizing government actions. One of the primary purposes of having a right to freedom of speech or freedom of expression is so that you can say, hey, the government sucks and is doing some bad stuff. That's what it's for, right? When you look at the background of why these things were put in there was because, I mean, the U.S. kind of had a whole revolution thing. And prior to that, like, criticism of the government was clamped down on. There's a reason why some of the founding documents, like the precursor documents that really got everything going, were written under pen names. So, yeah. Sorry, I'm snacking because I haven't eaten. And I've got, I'm being tempted by salad rolls. All right. It is emblematic of strategic lawsuits against public participation lawsuits across the country that are initiated to stop a defendant from expressing otherwise legal speech. They are absolutely on point on this, because it seems to me that the point here, like, as much as they say, oh, they're stealing our likeness, the point isn't that. The cops clearly want Afroman to shut up, right? The cops clearly think that he is embarrassing the F out of them, right? So, yeah. That's really what they're looking for here. All right. And hello, darkness, saying, fair warning, be prepared to be irritated by stupidity and poor lawyering. I hope you're not talking about me. I know you were referring to somebody who's starting at the beginning, but I hope you're not talking about me. I hope that's not where I'm at here. So defendant's statements regarding the plaintiffs were made in connecting with the defendant's music and are therefore opinions and art. Yep. And commentary of the defendant's raid, or of the defendant about a police raid on his house. The recorded video of the raid on defendant's house is a verbatim account of what actually occurred when a search warrant was executed. The statements allegedly made by defendants are therefore personal opinions and therefore accounting of events that occurred. Yep. Furthermore, the use of plaintiff's likeness is incidental to the commentary about plaintiff's actions as police officers conducting a fruitless raid, and thus this speech is protected by the First Amendment. Now, they might run into some trouble there with selling their, things on merch, but I think there's still good arguments to be made here. Actions by police officer that a citizen believes to be unlawful are certainly public matters of concern. Criticism of the government is at the very center of the constitutionally protected area of free discussion. So, citing Rosenblatt v. Baer from 1966. And they really could have cited like dozens of cases here or hundreds of cases. This is basically First Amendment or freedom of expression 101. The defendant cannot be held liable for speech protected by the First Amendment, and therefore the plaintiff's claim should be stricken or dismissed. If you guys remember in the whole Depp v. Heard thing, right? The argument that I was saying was the scariest argument for Depp. Like, the argument I was saying should have Depp most worried, and which thankfully Elaine kept blowing up right after it was made by Rottenborn, but was Rottenborn's argument about freedom of speech. That was their best argument. That was the argument that had me going, okay, there's something to this, right? every time I got blasted on Twitter because I said Rottenborn is making good arguments here, it's because he was making arguments hammering on the freedom of expression thing. And then, of course, Elaine would sail by in her boat and fire the cannons at his argument by making it completely crazy. So, yeah. So that's kind of what we're looking at here. Plaintiff's claim of invasion of privacy by misappropriation pursuant to the restatement of torts fails because any statements made by the defendants in this case are opinions and commentary protected by the First Amendment, and the plaintiffs gave their implied consent to be recorded by entering Mr. Foreman's home. Yeah, you don't really typically have much of an expectation of privacy in somebody else's house. Yeah. They note here the right of publicity, as recognized by statute and common law, is fundamentally constrained by the public and constitutional interest in freedom of expression. The use of a person's identity primarily for the purpose of communicating information or expressing ideas is not generally actionable as a violation of the person's right of publicity. I probably has a right to, have a, I probably have a publicity right in the sense that at this point, I'm known to, I guess, a little over 200,000 people, right? And, I might be able to sell a hot sauce better than I would have otherwise because people know me and its association with me, right? There's some value to that, right? I could possibly sell an endorsement to a different hot sauce and, people might be interested. I get VPN networks and so forth who are actually, reaching out going, we would like to pay you to do commentary. So that's like a publicity right. But if somebody wants to make a video that says Runkle sucks and here's why I hate him, I would not be suing them unless they were in some fashion defamatory, because that's not like, that's just communicating their opinions about me. So, yeah. I see Trent Van saying, don't do the VPN thing. I've turned down, or at least not responded to a dozen VPN requests. It doesn't seem likely. I'm not saying that I'm not open to the idea of endorsing a product. It's just that I would probably endorse a product that I like, and none of them have been like a VPN that I use. So, and I just don't know if I can judge if they're good VPNs or not. So, the statements alleged to be tortious are merely jokes, commentary, opinions, or artistic expression by an artist. The plaintiff cannot simply try to classify protected speech as tortious behavior to make a First Amendment cutout for themselves. That is a huge thing here, right? They're trying to basically say, you don't have this First Amendment right. And yeah, somebody's asking, do I use a VPN at all? I do. And somebody's saying, get endorsed by Manscaped. I've actually thought about Manscaped, but only if I could just actually use that only when it's funny. Like, yeah. Is there something wrong with VPNs? Curious, because I was thinking of getting one. Nothing wrong with them. They might not do as much as you think they do. But the thing is that everybody online is shilling VPNs, and it's annoying. It annoys the fan base, right? So, yeah. All right. So, the use of the plaintiff's likeness is incidental to the commentary about the plaintiff's actions as police officers conducting a fruitless raid, and thus this speech is protected by the First Amendment. Again, criticism of the government is at the very center of the constitutionally protected area of free discussion. I think this is the same quote that they're repeating, which is lovely. So, yeah. Somebody's asking, which VPN do I use? I'll hold off on that. But so, yeah. I'm not wedded to the one I use, so that's kind of why I'm holding off, because I might actually switch in a little bit. Holding the defendants liable for criticism of police officers would set a dangerous precedent for the First Amendment in the state of Ohio. Yeah, absolutely. If they find them liable, if they find Afroman liable here, how do you criticize police? Right? Hey, here's 3 cops beating up a black guy for doing nothing. We can't actually comment on this because their likeness is too valuable. No, that would be ridiculous. Even if the court believes that the plaintiffs have made a valid claim to misappropriation of name or likeness, they can't prevail on that claim because they gave implied consent to use their likeness when they entered the home of the defendants. I don't know if I agree with this because, I mean, there's permission that they might have given for one purpose, but not for another. Like they gave permission to be videotaped, but that doesn't mean that they necessarily gave permission to appear on t-shirts. So consent is a complete defense to the tort of misappropriation of name or likeness. If there's consent to particular conduct, the consent will prevent that conduct from constituting an actionable invasion of privacy. Yeah, the conduct here is not appearing on t-shirts. So that, I think, is a problem. By entering the risk of the defendants as employees of Adams County Sheriff's Office, they knew the risk they could be recorded by home video cameras or other recording devices. Yeah, but yeah, I just don't know that appears for the t-shirts and so forth. Plaintiff's claim of false light publicity fails because the statements made are opinions or commentary and are not untrue statements. So court stated that the tort of false light has 3 elements. Statement must be untrue, statement must be publicized, and the misrepresentation must be serious enough to be highly offensive to a reasonable person. Now, there might actually be some aspects on this, which is that, he did say some pretty nasty things about that one female officer. So they might end up with some trouble on that for false light. So, yeah. What was it? Fine Ape saying, I'm saying some form of hair care product would be a good fit for you. I don't really use hair care products. So, as I said, I don't endorse things that I don't use. So, yep. I see. How would putting them on shirts be different than putting them on big signs saying these jerks should be allowed to be cops? It's different when you're selling a product to a certain extent, but also if you're just selling it and it's just like a shirt of that guy, then that can be a problem. And yeah, some of the things Afroman said and did might get this some traction. Yeah, Afroman, some of his comments about especially that one female officer, I feel like might give the false light aspects. I think Afroman might have blown up the motion to dismiss here by some of those things. So even if the plaintiffs were to make a showing of the last 2 elements of the claim, they could not show that the statements were false. Comparing someone to Peter Griffin, the protagonist in the animated comedy show Family Guy, does not amount to a false statement. No, that amounts to being funny. Neither do any of the other claims of comparisons to fictional characters or other works of art. Neither is using a video of a raid conducting within your own home. In fact, in their complaint, the plaintiffs do not establish what statements are purported to be false for this false light publicity claim. I mean, they did actually say some things about, particularly that one female officer. So, and I feel like they're leaving that out here. So, yeah. This is a good thought. A company like that Finnish clothing company that starts with the V, Veristoleka. If Veristoleka reached out and was like, hey, we'd like to do a sponsorship, I would absolutely talk to Veristoleka. Veristoleka's stuff, I won one of their backpacks in a draw at a shooting competition. I quite liked it. So, asking a dumb question because I'm late, can a judge dismiss all the way to closing arguments? There's various points where they can dismiss, but yeah, you can absolutely ask for a dismissal even mid-trial. If we saw Depp v. Heard, they asked for dismissals mid-trial. So, yeah. Love Veristoleka. So do I. I've actually been meaning to order a bunch of stuff from them, so maybe I'll do that later. Plaintiff's claim of a publicity given to private life is insufficient and fails to state a claim upon which relief can be granted. Normally, this requires some release of things that are normally kind of hidden away from the public, right? And in this case, I feel like we're not there yet. Something like, the things that you do in your own private space would be, that kind of thing. But here they're talking about how they conducted themselves while on duty as law enforcement officers and while in his home, not their own home. So, yeah, any person under the Adams County Sheriff's Office jurisdiction would have a right to information about a possible unlawful search. So, and therefore any statements would be of legitimate concern. That one makes 100% sense to me. Plaintiff's claim of defamation is insufficient and fails to state a claim. So the founders recognized that eschewed silence coerced by law, what he called the argument of force in its worst form. He said it was hazardous to discourage thought, hope, and imagination, and that the path of safety lies in the opportunity to discuss freely supposed grievances and proposed remedies. I love that. Oh, yes, and we've got Canadian Outdoors BC. Welcome. So, yeah. I got to be careful looking at Veristoleka. I keep getting the itch to get a wool trench coat. Yeah, that is... there's a lot of stuff I want to order from them. I just kind of want to send a shopping list and just be like, I want all of these things. So, injunctive relief is not a civil claim, is an inappropriate remedy, and cannot bar the defendant's First Amendment right to freedom of expression. I'm just going to say it's very difficult to get an injunction against, free expression in like freedom of speech in the States, because typically what the courts will say is, nope, they get to talk. And only if the things that they say are improper can you then pursue something against them, right? So, yeah. So, not entitled to injunctive relief, cannot prevail on their defamation claim because they can't show that the statements are false, cannot show that the statements were made with malice, and cannot meet their burden of proof. I feel like the best claim is going to be that one female officer where he was calling her trans, he was calling her, saying she was gay, saying various other things. And I mean, it's just, he was going a little too far in the digs. He was getting, getting homophobic, getting, whatever else about her. And I feel like the court might take issue with those statements. So, yeah. I noticed that I haven't seen a single thing about that in this motion yet, and we're at page 10 of 19. So, yeah. So first, the general context of each statement the plaintiffs have put in their complaint. They were part of a raid of his house, which ended up being fruitless. He's a black man in a largely white area of Ohio that had his house raided by an all-white officers. It appears that his cameras were disconnected during the raid, and after the raid, he was missing an approximate total of $400 in cash. Each statement puts or sits within the murky waters of these circumstances. They note that he's an artist. He posted it on his artist's, page, making statements of opinion, not defamatory statements of fact. I mean, you've got some questions on that one, like the opinion that somebody's a thief can be taken as a statement of fact. So his Instagram username is OG Afroman, which reflects his stage name and not his government name. I don't think that's going to go very far, but I mean, throw it in there anyway. He released songs that criticized the police raid on his house, which is a valid gripe considering the fruitless nature of the raid. I'd agree with that. So, These statements either are not verifiable or wording that the statements show that they're opinions. Statements such as criminal camouflage by law enforcement or the white supremacists operating inside of the Adams County Sheriff Department are statements of opinion and are not verifiable. I think that's probably accurate, but what a criminal or white supremacist is to one person may not be the same to another. I feel like that holds better for white supremacist than it does for criminal, because criminal seems to be a person committing a crime, right? Whereas white supremacist is fuzzy. I feel like criminal has a much harder definition, but so none of these statements could be taken seriously taken as fact by a reasonable person. I think that makes sense. He notes that this is hyperbole, subjective, or just plainly taken out of context in each video. That I think there's a better argument for. So they have some theories that they're going to address. The officers are private figures. So that, as they say, in defamation suits brought by private figure plaintiffs, Ohio courts require a plaintiff to prove by clear and convincing evidence. That's a tough standard. That the defendant failed to act reasonably in attempting to discover the truth or falsity of or defamatory character of the publication. That's a tough standard. Plaintiff has not and cannot establish its defamation claim by clear and convincing evidence. That they're public officials. So what they're doing here is that they're arguing. He's arguing in the alternative, and this is very common in law, where you say, if one thing, then I win. But if the other thing, then I win. And if this third thing that's neither of those both, first two things, then I still win, right? That is kind of that's kind of how law is often done, right? And so this upsets people to no end when they see this in legal filings, because they're like, pick a road, because you'll have people say things like, in a statement of defense, let's say I went down the street and I punched a dude in the face. And they'll say, my statement of defense when he sues me might be like, it wasn't me who punched him. And if it was me who punched him, then he wasn't hurt. And if he was hurt, then it was his fault because it was in self-defense. And you're going like, which is it? Like, you say you didn't punch him, but you also say it was in self-defense. How is that the case? Like, how do you make these arguments? Well, that's law. So in this case, he is noting the officers are public figures or public officials. Apple Silver, no man has ever been shot while doing the dishes. I think that's actually incorrect. I think there was a case of a doctor who got shot through his window, but not by his wife. So while he was doing the dishes. So theory 2, the officers are public figures or public officials. A public official is a government employee or official whose position has such apparent importance that the public has an independent interest in the qualifications and performance of the person who holds it, beyond the general public interest in the qualification and performance of all government employees. That might sound like a cop, right? The public official category has been extended broadly. They note that naval officers haven't been included. Mid-level municipal employees have been included. And importantly, we've got this one case here. Gray v. Udevitz, policeman. Prior case law says policemen are government employees. Oh, that's going to be a problem for the other side. That'll be a problem for the plaintiffs. First Amendment protects a significant amount of verbal criticism and challenge directed at police officers. Absolutely. Unlike traditional common law defamation actions, a much higher standard of proof is required when the alleged defamation is against a person who is considered to be a public figure. So if this is a public figure, then we're looking at much higher standards, and it's going to be harder for the plaintiffs to win. Even evidence of hatred, spite, vengefulness, or deliberate intention to harm can never, standing alone, warrant a verdict for the plaintiff in such cases. Ooh, ooh. Um, the focus in these cases is the defendant's attitude towards the degree of truth or falsity in the publication. In order to prove actionable defamation of a public figure, the plaintiff must show by clear and convincing evidence that the defendants harbored actual malice while making the statements. And remember, Depp v. Heard, folks. Remember, actual malice doesn't mean that you're malicious. It doesn't mean that you are hateful. It doesn't mean that you are like mustache twirling evil. Actual malice is with regards to your approach to the truth. Right. This is an important distinction because this is one of those places, and there's so many places like this. This is one of those places where the sort of ordinary meaning of the language is not the same as our customary use of the language. So must demonstrate with convincing clarity that the defendant published the defamatory statement either with actual knowledge that the statement was false or with a high degree of awareness of its probable falsity. I don't think they're going to land there. I think this is great for Mr. Foreman because Mr. Foreman was missing $400 after the raid. That means that it's reasonable for him to form the opinion that they took it, right? His video cameras were disconnected during the raid. Why would you do that? I mean, quite frankly, why would you do that? Like, what is the purpose for disconnecting the video cameras? And simply, all of the statements were either opinions, jokes, or commentary made by an artist towards officers that the artist perceived that he had been slighted by. Yep. Plaintiffs cannot state that their personas have commercial value as is required by the code. I don't even see why the other side is arguing this, right? Under the plain language of the statute, the plaintiff must allege that his name, voice, signature, photograph, image, likeness, or distinctive appearance have commercial value. I mean, maybe mine does, but these officers, who knows who they are? I don't mean to sound like a dick there, but it's true, right? So it only stands if the name, likeness, or distinctive appearance has commercial value. Cool. The standard for establishing the commercial value of one's likeness is high under Ohio law. A plaintiff must show significant commercial value to state a claim. So in Harvey, an attorney brought a claim against defendants for use of the attorney's name in a continuing education course for realtors. In upholding court's decision granting summary judgment in the defendant's favor, which means they threw the case out without taking it to trial, the court held that the plaintiff could not successfully recover on a claim for the unauthorized use of her persona for commercial purpose because she was not a public figure or even a limited public figure and could not demonstrate that her name had significant value or indeed any commercial value. While plaintiffs need not be national celebrities to assert a publicity claim, they must at least demonstrate that there is value in associating an item of commerce with their identity. Now, keep in mind, the other side argued the same quotes here, but I think these quotes all lend towards the defendants here. And the defendant is Afroman, just to be clear. The officers are the plaintiffs. So, I mean, Afroman is getting his money not by suing them, but by making fun of them. So, yeah. Here, the plaintiff's complaint does not show that their personas have commercial value. They only state that they're employees of the sheriff's office and that their personas have commercial value because the reputation, prestige, social standing, public interest, and other values add value to any product or service with which the plaintiff's personas are associated. This does not equate to significant commercial value to satisfy the standard. It's simply an impermissibly conclusory statement unsupported by fact. This is great as a point. This is an evidentiary point. And people hate evidentiary points, but evidentiary points are important. He's basically saying you can't just say your persona has value. Freaking prove it, right? Show it. Put it in an affidavit. Put it in something, right? And I mean, I might actually be in, I'd be in a position to do it. I'd be able to go through my emails and be like, look at all these people who wanted to, who wanted to have sponsorship deals with me, right? I could put that in an affidavit. I could put those in as exhibits. Like, hey, we're with, whatever VPN. We want to work with you. Hey, we're with, whatever product. We want to work with you. Hey, we'd like to send you this stuff for you to review. All of this stuff, right? They can't do that because they don't have it. So there is no previous monetary value to the plaintiff's personas that is now being exploited. So, yeah. I actually think this is really well written, but I actually think it should have addressed the elephant in the room. And the elephant in the room here is some of the comments that Afroman made about that female officer. I think that's his weakest point. And his approach to dealing with it, Bruce Rivers' approach to dealing with it, is just to not mention it, which is a risky game because the court might be thinking, what if the court reads through your submissions and is thinking what I'm thinking, which is, what about this other issue? Then what they're going to be coming away with at the end of all of this is we have some how come you can't address this? Lacey Petit is saying, wait, there was a female officer. Yes. So, I mean, if I'm the judge looking at this, I would, be saying, hey, what about that? What about this point that you didn't address at all? And if you didn't address it at all, I mean, there's two reasons for that. Reason number one is that you think it has no merit whatsoever. That's a perfectly possible, if somebody says Runkle should lose because Runkle's hair is stupid, I probably wouldn't even address that in my response. But if somebody says Runkle should lose because, and they provide a bunch of reasons and they're like legal reasons, I'd address that, right? So, yeah, that's kind of, I think that's a problem for him in this filing, but otherwise it's really well written. I really like this, but it's really easy to do well-written things when you are in a situation where, quite frankly, I think Afroman has the better case. I've been wrong about things before, but I would be very surprised if Afroman loses this. I would be very, very surprised. I see FYI and off topic. Global News projecting a UCP majority government now. Let us bring up, I can bring up that screen here. Now, keep in mind, folks, land doesn't vote. So this is what Alberta almost always looks like, but you see the projection is a United Conservative majority. These big ridings are because they have very few people in them, right? Because they're a lot of farmland, right? And so land doesn't vote, but you end up with this tremendous amount of blue in various places. But then when you look at Edmonton is orange. Looks like it's entirely orange. I'm just trying to see here where, yeah. So Edmonton is orange. Calgary is orange, but it doesn't look like they gained enough. You see where, if you want to see where they lost, it's these outskirt areas here. These outskirt ridings are a problem. Whereas Edmonton, they pretty much own the entirety of Edmonton. They lose Leduc-Beaumont, but they basically own all of the Edmonton ridings. I think Calgary is what's decided it with the with these outskirt ridings. So is what it is. I don't like any. I don't like politicians in general, but yeah. All right, sorry, back to Afroman. I got distracted by the shiny thing. Um, yeah, UCP won a couple of key spots in Calgary from the NDP that they needed, apparently. Yep, it's those outskirt areas. So basically, I think that Afroman really ought to win this one. Afroman, if he fails to win, the impact of this on criticism of the police, at least in Ohio, is tremendous. So yeah. Hmm. Hez or A or sick. I'm gonna. Can you name the sauce after McSquirrel? I am not going to name anything I'm selling after Squirrel. And the reason why is because I'm hoping to make. I'm not going to be seeking a huge amount of profit, but I'm hoping to make money on the hot sauce thing, right? Um, Secret McSquirrel, she's not there for me to make a profit off of. Um, that's not, so that's not what we're doing. I will probably do a video talking about Secret's funeral and send off, and so forth at some point. And I can tell you when I do that, it will be I'm going to have super chats turned off, and we will instead. I'm trying to decide which charity that would be for, but it'll go to a charity. If you want to donate money during that, it'll be to a charity, not to me, because that's not how we do things here. Um, Secret has, she's always been, a great supporter. Um, I am not we're not going to turn that into something else, right? So yeah, that's just sort of what we're looking at there. I see the UK has Stand Up to Cancer. Some of the possible options. Somebody suggested the Extra Life fundraiser. It's an option, but it's not my favorite option. Just because people would say, "Hey, that's still too connected." I could do like a UK cancer sort of drive there. There's also charities for birds. She loved her birds. She had so many birds. And the other one is another one is that there's a UK or a Scottish squirrel sort of rescue organization. So those are kind of my thoughts on that as options. And yeah, we're not going to, but yeah, I'm not gonna put her name on my hot sauce. I'm not gonna anything like that. Anything, another thing is she was big on the cabaret scene in Scotland, and so yeah. Caffeine Junkie is saying, "Did I get to meet her birds?" No, her birds were rehomed. I did sort of get to meet her birds. If you watch the Stars Without Numbers stream, you can see her birds there. So we're gonna do something, but yeah, that's for down the road. But I'm not gonna use her likeness like that. That's not that wouldn't be cool. So instead, we're just going to sort of do what we can here. But yeah. So that's the Afroman case. I actually think that the Afroman case is it's a really it's a funny case, but it's really important. I think it's a really important freedom of speech case, and yeah, it's just I will be shocked if Afroman loses, and quite horrified, to be perfectly honest. So here's hoping here's hoping he wins. And what I hope he does is I hope he wins and then turns around and makes another song about, these cops sued me and I kicked their ass in court. So, yeah. I see. Can we big Afroman up any? I don't know if we can. I don't know if we've got a sort of way to do that. I'm also going to I'm going to be reaching out to some of the people who were in her life, some of the people who were sort of some of the performers and musicians that were around her, to see if I can sort of share some of their content. And if they say no, that's perfect. Like, we're just going to respect that. But she had some good people around her, and it was just, I wish I could sort of share all of that with you guys. Now I'm feeling a little melancholy, and here I am with a scotch. And all right, is there anything I promised I would talk about that I have not yet talked about? Because I think, let's cover super chats and so forth before we'll just do a swoop. Swoop-de swoop. All right. Skeesy, thank you very much for 5 gifted memberships. Angie Torres, thank you very much for 10 gifted memberships. Much appreciated. Koru, thank you for 5 gifted memberships. And Crafty Norwegian, thank you for the member chat, saying good morning. Good morning. I really enjoyed Norway. I would love to go back. Although Norway is stupid expensive. It's just, it's not cheap at all. Kathleen Chan, thank you very much for the YouTube membership. Much appreciated. Marcel Dufour, did you know all the vampire stories are from Europe and not Africa? And then I realized vampires are killed by holy water and they bless the rains down in Africa. Thank you very much. And I feel like we could use a little bit of lightheartedness there. I was about to say, no, you're wrong about that. There are vampire legends from Africa, but I see where you were going there. So, I see. Can we get a specific, non-specific progress bar towards achieving your YouTube/lawyer dream? I have to figure out what the math is on that, but we'll have to sort of track that out. So we'll have to just figure that out. Delirium, Runkle, where can we find the video of your Supreme Court appearance? It's on the Supreme Court webpage. It's the case of it's R and GTD, so RVGTD. So check that out. You'll have to do a search there, but then you can find the video. I don't have the link handy, and it's a bit of a pain to navigate. So, Joe Loy, great chat that has ramifications across the board. Nice chat group also. I just want to say I'm really happy because I have I think I've got a great chat, and I mean, I don't want to just blow smoke up your butts, but it's I like that I come on and you guys are cheerful, you guys are happy. People aren't fighting, people aren't anything. People are just chill. It's a group that I like hanging out with, and I really appreciate that. It's like, let me tell you guys, if I had a chat that was a little more sort of aggressive and angry and all of that, I couldn't do this show. And the reason why is because if I came through and was like, hey, and if I knew you guys were going to be snarky and snippy, and I'm just going to have to like police you guys and like, spend a lot of time banning people and timing people out and so forth, it would feel like work. And I already had I had a day of work, right? This is my way of like, I have a Monday. Monday sucks a lot of the time. Monday especially sucked for me today because I am still jet lagged from Scotland. My brain is still on Scotland time, and I am still. So I got up with like 4 hours of not great sleep, and I struggled through today. It was a long day. And then I get to come here and hang out with you guys. And you guys were patient when I was struggling to find some of the things and some of those, you guys were helpful. I really like spending time with you guys. It's nice. I'm just happy to, I'm happy to have you guys as a chat. You guys are the greatest chat around. And I like Rob's chat, although a lot of the chat's the same chat. I like EDB's chat. Again, a lot of the chat's the same chat. It's really nice to have that. So, yeah, I saw somebody saying that it's a bad idea to share ad revenues on a live. That's fair. I don't know if they would mind if it's an aggregate or just a bar, but I don't actually know at this point. I'd have to actually figure out sort of what sort of income I need for that, and I don't know what that is yet. So I have to sit down. One of the things I have been thinking about is that I'm thinking that Roll of Law is going to be basically my sort of fun money channel, if that makes sense. Which mostly means, I'm doing that giveaway for that. I got to give more clues. I got to do another video and give some more clues on that. But I've decided that it's going to be like, I'm going to pick out some of the things that I just kind of want to, that like a laser that I want to get, right? And just say like, next thing I want to get is a laser. And then I'll put like a progress bar to laser for that. So, that's kind of a thought there. So I don't know if that's stupid or not, but I'm kind of thinking that I might put in like, here's the progress bar to lasers, or here's the progress bar to a CNC machine or a lathe or something like that, and just whatever silly crafty thing I'm looking at doing, and what is it? And yeah, I'm a big fan of the fact that these, like, I've been able to have the tremendous privilege of raising some non-trivial money for charity. So that I think is super lucky. I'm really glad to be there. All right. Equality, thank you very much for 5 more gifted memberships. It's much appreciated. Ian, how old are Zora and Potter? Says Trufflehound. Zora is, I want to say 3, and Potter's probably like 9 now. Potter's getting to be a bit of an older gentleman, but he's a really good dog. He's still very active. He's still very exciting, and yeah. So, Fine Ape, I love the suggestion. I will have to get that set up. That's a great one. Equality, love hanging out with you too. Your humor helps me get through a day sometimes. Hope the weather's decent there. Weather's pretty good, although I've got to say, I would love to see some rain. We have not enough rain here. I want to have a fire in my backyard fire pit, and we can't because right now there's still fire bans. So yeah. Kristen M96 was trying to sew and listen tonight, but hi. Kristen M96, can you send me your address? I would like to I'd like to send something your way when I get a chance here. People are asking, how bad is the smoke in Edmonton? Not bad at all now. So yeah. And Lara M, this is a great question. Did you ever do your doggo cam outside? Not yet. I want to get that set up. I'm thinking I may need to get like an outdoor wireless camera and just mount it on my, mounted on my house. So then I can have the doggos running around out the back. And then I'm thinking I should do like a stream where it'd be like, hey, for this much of a super chat, I will fire the ball out of the dog ball cannon. For this much of a super chat, we'll give them some sort of snack. We'll, that kind of thing. Although Potter right now is on reduced snacks because Potter is, he's got, his legs have had surgery. So the vet doesn't want him to get too chonk. So we need to reduce or keep his minimal chonk. So that is something to be looked at. Is there a brand of laser you have your sights on? I haven't decided yet. So we got to sort of figure that out. So we got to figure that out and go from there. Yeah, they can't get too chubby because we got to keep Potter's weight within certain levels to keep his legs stable. So all right, see, if you do a dog cam, then rig a treats dispenser so people watching can tip and launch a treat for them. You'll make ridiculous money, and both the dogs will have diabetes. I can't let Potter get too chunk. He's a good dog. And we want him to stay happy and healthy. All right. And yeah, people are asking how the fires are. Alberta's getting better, but now there's fires starting in the East Coast. There's just going to be a lot of fire this season, it seems. So, yeah. Wireless camera. Why wireless? Because it's going to be hard to put a wire up the wall. You know how Zora eats wires. That's why wireless, because Zora loves eating the wires. 1 calorie training treats. That's not a bad idea. So, all right. I'm going to let everyone go. Dogs are family members, not just pets. My dogs certainly are. I love the dogs. So, yeah, the dogs are good. In the U.S., the vets are now calling chunky pets overconditioned to not insult the owners. I would say that they are. My dogs aren't too bad, but yeah, they're gonna get. I need to keep them from getting chunk. That is that's important. All right, let's sort of wrap this out here or wrap this up. I will probably head into the garage for a little bit. I'm going to do some leather work because I just kind of feel like I'm working on something for David Prototopics, and I want to make sure that that it gets done. So we'll see, but I've got to do a lot more work on it. I'm feeling pretty proud of it. I'm hoping to be able to show it off at some point, but I got to make another panel. Did I decide on the final panel? I've got a few options. I'm going to play around in Midjourney to see if I can generate something that I like. So, yeah. I can tell you that the thing I'm going to have made for David will probably be something that would be north of like $1,000 later if I were to have sold it. But I'm just giving it to him as a gift because it's I love his DMing. He's a great friend as well. It's just a thank you kind of thing. So we'll see. I'm hoping I can show off the finished product eventually, and I got to learn some more techniques for it later on. So, all right, let's roll the outro. Annabelle, I see the member chat there saying, thanks, Ian, for a great Monday night. Thank you as well. And let's roll our outro, and I'll see you guys next week.